24th, I'll not be here.
You're not there. Eta mone rakho.
26th and 27th is the Ratha Yatra.
So which dates you are not there, please? Hey, likhe rakho ota.
24th and 27th, I'll not be there. On that week, huh? Bro, I am recording the before the register. Honorable register, my
please.
Deeply obliged.
Thank you.
I have come from Chandigarh only for this matter. Again, I will go back to Chandigarh.
Sorry about that.
It doesn't matter. It happened.
I'm happy. With the leave of my I'm happy for the other containers.
We will display the matter at least 2 days before the. আমার সঙ্গে যে কথা বলবে তুমি গিয়ে. Yes, Mr.
Mrs. Chatterjee, I am mentioning that matter, metro rail matter, all arguments have been exchanged between the party. Only to file it.
With Justice Chando.
With Justice Chando. Once again, I am traveling here, Lordship.
Metro rail.
Metro rail. To be mentioned, it can be given because the parties have exchanged their affidavits among themselves. We have to file
affidavits.
No, written notes of argument. Exchanged among the parties.
কথা বলো আমার সঙ্গে আজকে.
So only we have to file the written notes. But that was the order all along. I have given the order.
You're mentioning upon notice, Mr. Bera?
Sure.
Are you mentioning upon notice?
Some notice. I have some.
May I have your lordship's kind leave to mention an appeal, my lord? The regular appeal from an intellectual property matter. But the only urgency with this is right now, my lord, there were 2 joint special officers appointed. One from the appellant side, one from the respondent side. Now, our instructing advocate, my lord, has changed. So, the concerned joint special officer who was appointed, my lord, he has to be discharged. And the new instructing advocates, my lord.
Only to that extent, for the time being.
For the time being, my lord.
To be mentioned there.
Because there is a bank account, my lord, which is being operated, my lord, for that purpose.
You are for the other side.
Yes, my lord. I'm for the appeal. I'm led by Mr. Banerjee. He's there virtually, my lord. Mr. Ratnanko Banerjee, my lord.
Where is he? In Paris? No.
I wish, my lord. I wish, my lord.
He wishes, but he's not there.
To be mentioned, ye kabe diye do, kal purshu kabe diye do.
Grateful.
Grateful. May I have your lordship's kind leave, my lord. I'm seeking leave to, my lord, file with short service and also file offline because the appeal is tomorrow. Now there's an application filed in connection with the appeal because despite of an order of interim order, my lord, there has been shares which have been transferred. That needs to be brought on record, my lord. This is, my lord, the section 9 from which they got dismissed and section 37, my lord. Kindly, my lord, grateful. May it appear tomorrow, my lord, along with the main appeal. Grateful, my lord.
With your lordship's leave, can I...
Serve.
Yes, we'll serve, my lord. This. Grateful.
With your lordship's leave, may I mention one matter before I let you?
Yes.
Your lordship, this order was passed on 13/12/2024, your lordship. This is a contempt application arising out of that application, my lord. And he is suffering from extreme penury, your lordship. He is to undergo a major surgery, your lordship.
Yes, give the number, give the slip.
Here I am entering.
In non-commercial, I don't know 1 and 2, your lordship fixed today.
Original side.
Non-commercial,
Non-commercial 1 and 2, yes.
That matter, your lordship directed me to submit the notes of argument today.
No. We granted you liberty. We did not directly. There is a difference between the two.
Yes, I beg your apology,
Yes.
But Mr. Amitabh Chaudhary, due to his illness, he did not able to prepare the same.
Chaudhary? You don't even know the name of your own counsel. Why should we grant you any indulgence? What do you want?
3 days accommodation.
Not this week. Hey, on the prayer. কোথায় কে আছে?
Mine is ready, lordship.
On the request made by Learned. On the request made by Learned. This virtual thing doesn't work. Connectivity is so bad. On the request made by Learned Advocate for the appellant.
Yes,
appellant.
Cross objector and they are the appellant.
They are the appellant.
I am the respondent.
For the respondent in APOT 68 of 2025, let this matter stand adjourned for the week.
Yes.
May I have my lord's kind leave to mention a matter for inclusion The only urgency is that
After the, sorry, yes, inclusion, yes.
our only urgency is that others has already filed a contempt application against me, which is pending before the under single judge.
Very good, you give it, it will be listed.
Obliged, my lord.
Original side commercial division, new application item number 1 and 1 more.
I appear for the respondent, Lordship. My lord, I'm for petitioner, my lord. I'm praying for not today, my lord.
I am for the respondent, Your Lordship, in this matter. Am I
Yes,
audible, Your Lordship?
Appellant is asking for a day's accommodation, Mr. Sengupta.
It's a Section 5 application. I would like to file affidavit. If Your Lordship allows me, otherwise, tomorrow I'll come. No problem.
How much is the delay?
551 days delay.
Let them file affidavit, madam, so that it progresses.
Kindly not today, my lord.
What not today? We are not. We are only giving direction for affidavits. Hey, Yeshoto.
I am grateful.
Accommodation is prayed for on behalf of the appellant. Paragraph: learned advocate for the respondent says that this is an application for this corona. There is an application for condonation of delay of 500.
551 days, Your Lordship. 551 days, Lord.
551 days in presenting the appeal. Stop. He has instructions to pray for leave for filing affidavit in opposition to the condonation application. Paragraph: let affidavit in opposition be filed within a week from date. Stop. Reply thereto, comma, if any, be filed within 5 days, within a week thereafter. Within a week thereafter.
Written notes.
What?
Written notes of argument. Last occasion, Honorable Court directed to submit the written notes of argument.
Commercial item number 1.
Oh.
Commercial.
Beg pardon.
Paragraph leaves the matter a fortnight hence.
Grateful, Lordship.
এই ভদ্রমহিলা এখানে আছে কি অফিসার কোর্ট অফিসার ভদ্রমহিলা আছেন না চলে গেছেন একবার
My lord, item number 2, my lord, I am appearing for item number 2. I am the respondent in OCD 2, my lord.
আপনি আসুন না এখানে একবার কাছে।
যেটা রেকর্ডটা মেনশন হলো আগের দিন একটা রেকর্ড করে চেম্বারে খুঁজে পাওয়া যাচ্ছিল না নাম্বারটা একটু জেনে নেব এই দুটো রেকর্ড একটু দেখে আমার চেক করে নেব চেম্বারে পাঠিয়ে দেবে বুঝলেন কি বললাম যেটা মেনশন হলো আগের দিন একটা রেকর্ড আমরা খুঁজছিলাম পাইনি সেই রেকর্ডটা দেখবেন খুঁজে বার করে চেম্বারে পাঠিয়ে দেবেন কোথায় কি আমি জানি না তাহলে তো আমিই দেখে নিতাম
Item number 2.
My lord, I am seeking your lordship's leave to appear virtually, lordship.
Why?
My lord, I am in Rajarhat, lordship. I could not.
This virtual thing doesn't work. Connectivity is bad.
Lord, I will be.
I was not supposed to appear. Have you given? This,
You are leading her.
I'm not engaged every day, my lord, for the matter.
Oh.
But in view of this, my lord, I'll appear, my lord, and I'll take over.
Very well. Who's for the? You're for the respondent. Mr. Chaudhary, you're for the respondent.
Yes, my lord. In this
Lordship, I appear on behalf of the appellant. By an order dated 22nd May 2025, your Lordship was pleased to direct
that
us.
Madhya Pradesh OL.
Yes, sir.
Hey, dekhi.
Lordship was pleased to direct us to serve them a copy of the report to the respondents. We have done so, your Lordship, by an order dated 22nd May 2025.
Yes, Mr. Chaudhary, have you seen the report?
Yes, my lord, now. But, my lord, what I find, my lord, I'll just tell your lordship the background. My lord, this is, my lord, in respect of certain shares. My lord, decree was obtained upon notice, my lord, to the owner of the shares, who's in liquidation now. My lord, decree was
Owner of the shares was a company.
yes, my lord. I think G.R.G. Rao Cotton Mills Limited. Now, these are shares of Grasim Industries, which, my lord, with the passage of time, is now, my lord, quite valuable. Now, the plaintiff, my lord, obtained a decree for, my lord, delivery of these shares. After about, my lord, 11 odd years.
Plaintiff is Prem Kumar.
Yes, my lord. Now, my lord, this is upon, my lord, it really ex parte because, my lord, G.R.G. Rao, my lord, hadn't appeared. Now, it was put into execution. In execution, my lord, a defense of limitation was taken up by Grasim. My lord, we were able to, my lord, cross that. And, my lord, Grasim now files an appeal and takes a point that as at the date of the decree, G.R.G. Rao was in liquidation and the official liquidator had not been served.
I see.
So, my lord, this is the principal issue in the appeal.
So we'll have to hear the appeal.
Yes, my lord. In the meantime, my lord, before the appellate court, what had happened was these issues, my lord, had come. Whether there was notice actually served or not had come up. Initially, it was believed that, my lord, there's a report that notice was not served. Then, my lord, we were able to find out that perhaps it was, which is why, my lord, that issue, my lord, paled into insignificance, and, my lord, the appeal has to be heard. My argument in the appeal would simply be, my lord, that these are not issues available to you, and the decree, my lord, without substitution of the official liquidator or without notice is not void.
What does the OL say in the report that he has filed?
My lord, I had a very cursory glance because, my lord,
Go through it. Come
Yes.
back.
yes, my lord, I find, my lord, page 2, my lord, paragraph B is that he didn't have notice,
Very well.
which is an admitted position. my lord. So there's nothing more.
এই একটা এসো তো ছোট্ট করে the brief facts of the case culminating in this appeal appear to be that the respondent number 1 herein, Prem Kumar Chaudhary, obtained a decree against a company which is in liquidation, for delivery of certain shares in the appellant company by that company in liquidation to Prem Kumar. Stop. The decree was put in execution. Stop. Grasim, the present appellant, took a point that what is barred by limitation? Execution is barred by limitation. That the execution application was barred by limitation. Stop. Such point was negated by the executing court. You have received the shares. No. Stop. Paragraph. Now, Grasim has filed an appeal assailing the decree.
I'm sorry, my lord, assailing the order in execution and calling the decree as void.
Acha. Assailing the order passed in execution, contending that the decree obtained by Prem Kumar is void since, as on the date of passing of the decree, the judgment debtor was in liquidation and the official liquidator was not put on notice. Stop. Paragraph, we need to...
Yourself, Ms. Chatterjee, mute yourself.
We need to hear out the appeal. Stop. Ready for hearing.
We can do it on these papers. It's on a point of law, my lord.
All papers are all necessary, relevant papers. You will be arguing the appeal.
Your Lordship, my senior would be arguing the appeal. I'm being led by Mr. Pratik Ghosh. He'll be arguing the appeal. Your Lordship.
When should we keep it?
Any day convenient to your Lordship.
So let it remain in the list. I'll do it on the next. It is not a very time exhaustive
Yes,
matter.
no, we will change the heading.
Yes,
We will
yes,
not,
of course.
not new application.
I'm sorry for that.
This GA is a stay application.
Your Lordship, there is a stay application.
Paragraph. Learned advocates for the parties say that all relevant papers are before us as part of the stay application filed in this appeal. Stop. We will hear out the appeal, treating the stay application as an informal paper book. Stop. All formalities are dispensed with. Stop. Since এটা কি কমার্শিয়াল হচ্ছে না নন কমার্শিয়াল? কমার্শিয়াল।
Commercial হচ্ছে।
No, the AR 1962 Calcutta, no?
Since you represent all the respondents,
No, my lord. I only represent respondent number 1.
how many other respondents are there? Who are they?
My lord, there's Citibank, there's my lord,
Here for the Citibank. Who else?
my lord, there's the official liquidator. Now he has notice.
So that's all.
That's all.
Since you are the respondent number 2 or 3.
3, Your Lordship.
Respondent numbers 1 and 3 are represented, comma. Notice of appeal is deemed to be waived insofar as those respondents are concerned. Stop. Let a notice be served on the official liquidator attached to the Madhya Pradesh High Court.
Obliged, Your Lordship.
Madhya Pradesh High Court, intimating that this appeal will be heard on bolo kobe next Monday.
Yes.
Next Monday.
Yes.
তারিখটা দিয়ে দাও। 23. You
Can
intimate.
it be any other day apart from 23rd, Your Lordship? Any other day apart from
Yes, can be
24th or any other?
30th. No, let it be a Monday when yes commercial matters are taken up first.
Okay.
30th.
30th, Your Lordship.
In the meantime, you notify the OL. In all probability, he will not appear,
Yes.
but serve notice.
Because I think the liquidation would also have been over by now. Also, the liquidation proceedings actually never end with the official.
Correct.
That's
Report, they say it's ongoing, Your Lordship.
ongoing.
They say it's ongoing.
All right, come back on 30th.
Remember, Justice Sanjeev Banerjee once said that I'll appoint if you don't settle, I'll appoint the official liquidator.
Yes, that is a real threat.
Real.
Grateful, my lord.
Item number 3.
Rather interesting situation. My lord, we money lent and advanced. We my lord filed a commercial suit. In the commercial suit, we wanted an injunction in the nature of my lord an attachment, restraining operation of bank accounts, alienation of assets, etc. That the money was lent is my lord by bank transfer. It's fairly admitted. Issue raised, my lord, that this is not a commercial suit because there is no document of lending. There is no commercial document, so it can't be a commercial suit. My lord, before the learned judge, when the injunction application was my lord taken up, it was found that prima facie it's not a commercial suit. Therefore, the
Plaint was returned.
no, my lord, on the injunction application,
Okay.
prima facie not a commercial suit, order refused. We've my lord come up. Later, my lord, the order 7 Rule 11 comes up for hearing on the same ground. But by then, my lord, the written statement has been filed. The learned judge, my lord, finds that in the written statement, there is a document which shows that this is prima facie a commercial proceeding.
He records an order to that effect.
Yes.
Then what remains
My
here?
lord, I come up in appeal now. We, my lord, praying for an order of injunction on the order 7 Rule 11 judgment.
Now that the learned judge has found it to be a commercial suit, the ground for refusal is gone.
Gone.
Go back.
That's also possible, my
Go
lord.
back.
Why not?
Yes. Esho.
My lord, may I just read the judgment once, my lord? My lord, page 369. My lord, just one paragraph, my lord.
This is the impugned order.
No, my lord, this is the order 7 Rule 11 order. My lord, 12th of November 2024. It starts, my lord, at page 364. And my lord, the operative portion, my lord, is at page 369. Lord, I'll just read that one sentence. This court has gone through the written statement and found
that the defendant has disclosed one document being Annexure E in the written statement with regard to the transaction made between the plaintiff and Anil Kumar Chaudhary since the year 2014 to 2022. This document corroborates the statement made by the defendant in paragraph 7A and B. Thus, if the written statement filed by the defendant is read as a whole and the document relied upon by the defendant being Annexure E to the written statement is taken into consideration, this court finds that the defendant has admitted that the transaction is commercial in nature. Accordingly, court does not find merit in the application. GACOM 4 is dismissed. This is, my lord, the subsequent order. Now, my lord, kindly take the memorandum of appeal, my lord, which has the impugned order.
Yes, 31st of January.
31st of January. My lord, after noting arguments, my lord.
No, but Mr. Chaudhary, 1 second.
Yes, my lord.
This this order holding that it is a commercial suit
Yes.
precedes the refusal order.
Yes.
So then the story is different. Then if the refusal was not on the ground that...
No, subsequently there is an order from which you went to Supreme Court. Yes, my lord, please see paragraph 17, my lord, once.
Of?
He has held that it's not so. My lord, please see, my lord, paragraph 17 of the impugned order. Hey, which is that order? No, this is prima facie not a commercial suit.
I said 13A.
Oh, my lord. That is in the chapter 13A order.
That is pending.
So the refusal, Mr. Chaudhary, was not on the ground that
This is on a separate ground, but my lord, what I was referring to, my lord, is page 353. At my lord, page 357, my lord, this was the principal roadblock for us. My lord, page 357, paragraph 12. And then, my lord, paragraph 19. And paragraph 21 at page 360 is the finding. The plaintiff has in paragraph 2 of the plaint mentioned that the plaintiff is engaged in the business of financial intermediation and financial activities and had lent money to the defendant for commercial purpose, but there is no mercantile document entered into between the plaintiff and the defendant. Plaintiff has also not disclosed any document either in the plaint or in the present application. Considering the above, this court finds that the issue raised by the defendant is a triable issue which can only be decided during trial.
So this order was passed on a 13A.
13A, from which, my lord, we are now in Supreme Court. After, my lord, we went, my lord, my lord, please see page 362. This is the Supreme Court order. This is dated 31st January 25. And on 31st January 25, the impugned order was also passed.
What happened in Supreme Court after
Supreme
4
Court,
weeks?
my lord, it's there. It's pending. So, my lord, this is the situation. The real roadblock, my lord, lack of urgency or not lack of urgency is something, my lord, which I can argue on. But this, my lord, finding in the chapter 13A application is what I felt, my lord, was the principal roadblock. Because once the learned judge finds it's prima facie not a commercial suit, there is, and without getting rid of that order, there is no way I can get an interim order in the suit, even in appeal.
But you showed me some
But
orders.
that is now diluted by this subsequent order, which I showed you a lot.
Correct.
So, my lord.
So if that be so, then now renew your prayer.
Yes. So, my lord, kindly grant me that leave to, my lord, renew my prayer by filing a fresh application. And if I show, my lord, grounds of urgency, my lord.
The problem is, Mr. Chaudhary, the impugned order
Yes.
refuses your prayer, not on the ground that it is a non-commercial suit.
Yes, on the ground that, my lord,
On merits, you have not made out a case.
merits have not made out a case. But, my lord, in my mind, my lord, when I challenge this order, merits, my lord, I can try and satisfy your lordship, my lord, that the usual averments are there. Maybe because it's an admitted money lending, I can get, my lord, some relief. But my principal roadblock, my lord, was that order in the Chapter 13A application. With that, my lord, I could not have, my lord, even opened my mouth. But that is now diluted by the subsequent order. I made a slight mistake when I started, my lord. That, my lord, is diluted. So, my lord, either consider the question of urgency on, my lord, in the appeal, or, my lord, permit me to now go back before the learned judge, having regard to the subsequent finding in the Order 7, Rule 11. But this is the situation, because Chapter 13A, prima facie view, not a commercial
I
suit.
understand. Again, the problem is again the same. What do we say regarding the impugned order? It is the learned judge has refused your prayer on merits. Being
I can show, my lord, the stay petition
Hmm.
and the interlocutory application. On the, you know, till the time this subsequent order came, I could not have opened my mouth, because that order, my lord, stared at me. If it's not a commercial suit, I can never make out a prima facie case. But now, with that being diluted by the Order 7, Rule 11 order, my lord, I can show, my lord, from this, my lord, interlocutory application, that perhaps I have made out a case.
Very well. Let us send it back then. Hey, Eshuto.
My lord, practically this is the second round litigation, my lord. And the first round litigation, interim order was refused and no appeal has been preferred. Subsequently, injunction application was hard contested in the first round litigation and appeal was preferred at the instance of the defendant. And in appeal, IL succeeded. The order of injunction was set aside on the ground that 12A has not been complied with.
My lord, I'll
And thereafter, after compliance of 12A, filed the second round litigation by suit.
my lord,
And interim order was prayed and refused. No appeal was preferred. So no urgency was there. That's why no appeal has been preferred against the refusal.
Sir, we are not going into the merits. He says, your learned friend says that initially he was unable to obtain an interim order because the learned judge was of the view that this is a non-commercial suit. Now that stand has been diluted by a subsequent order of the learned judge, single judge. So he would like to renew his prayer before the learned single judge. We'll just record this bit, nothing more, and send it back.
Yes. Also, my lord, in this order, there is also a finding in the impugned order.
Yes.
My lord, plaintiff has not disclosed any material that the defendants are transferring or transferred their property to third party, or is transferring the amount to third party without paying the dues of the plaintiff. The defendants have taken a specific defense that the defendants have no contract with the plaintiff and all the transactions were made between the defendants and Anil Chaudhary. So this was also, my lord, a ground that no contract with the plaintiff. So that was playing on the learned judge's mind. The whole thing, spectrum changes after the finding in the Order 7, Rule 11 order.
Yeah, sure. This appeal is directed against a judgment and order dated January 31, 2025, whereby the appellant's application being GA number 1 of 2023 has been dismissed by...
One thing I should say, my lord, in fairness, this is, my lord, dated 31st January. Order 7, Rule 11, my lord,
precedes
is
this.
on 12th of November.
Yes.
So, my lord,
that is the
that's
problem.
the only thing I should have pointed out.
No, I noticed that. That is the problem. Even after diluting, so therefore you can't say that this order refusal was on the basis...
Without noticing that. That I cannot say, but now that this divergence is there, your lordship will hear the appeal, I'll argue, my lord. My lending is, my lord, admitted. At some point of time, my lord, I can show that, my lord, lending is admitted, TDS is paid, and you have not repaid
Yes,
me.
but still, it's a money claim.
It's a money claim.
The learned judge has discussed all those cases that just because you have filed a suit claiming a money decree, that wouldn't restrain the defendant from dealing with his properties. I mean, that's established law, unless you can come within Order 38, Rule 5.
Now, my lord, but that's changed now. That's changed now.
You have to show something. Just a money claim, why should be secure?
Admitted money claim.
Admitted money claim.
Or my lord,
No, no.
unimpeachable money claim.
You are saying so.
Yes.
But point is that there is no admission. There is no Order 12, Rule 6.
My lord, rephrased what I said, my lord, that it's.
No, I don't think we can send it back.
I think that's better, my lord.
Yes.
May I do it?
Yes, you have to do it.
Next day, let me do it.
Yes. All papers are here?
Yes, yes.
Yes. So we'll hear out the appeal. We'll dispose of the stay application. লেখো কি বলেছিলাম সেটা থাক, যেটা বলেছিলাম ওটা থাকবে। Dismissed. Paragraph. We propose to hear out the appeal. Stop. We are told that all papers that were available before the learned single judge have been annexed to the stay petition. Stop. You appear for all the respondents. Stop. Since the respondents are represented, notice of appeal is deemed to be waived. Stop. All formalities are dispensed with. Stop. We shall hear out the appeal treating the stay petition as an informal paper book. Paragraph. The stay application stands disposed of. Paragraph lists the matter under the appropriate head.
On the next day, my lord, when it's
Next Monday.
Yes, yes.
Next Monday.
2 weeks.
2 weeks.
Urgency নেই কিছু।
30. You have another. We have
Yes,
fixed
yes.
another.
Now I'm not going to go gallivanting here and there.
30 তারিখে।
But I'll also try and show, my lord, that having regard to the development in the law, your lordships have now, my lord, almost made it axiomatic that unless you can come and show some form of defense to a money claim, if it's a clear case, your lordships will not grant an order of injunction to.
No, if it is a clear case, what stops you from, and your 13A didn't succeed,
Yes, on a ground which is now diluted.
which is before. Oh, you didn't carry it to the division bench.
No, it's, my lord, straight to Supreme Court.
13A,
It's, my lord, not appellable.
13A refusal is not applicable.
So, my lord, this is a commercial suit. This is order 13.
Oh, yes. Commercial suit.
Problems, my lord. So therefore, my lord, we had to go.
Very well. Let's review the law on
Yes.
this point. Yes.
It's very interesting, my lord, and I have consistently lost. The biggest challenge, my lord, I had was I cited all the judgments trying to say can't be a decree against Mr. Ratnanko Banerjee, miserably lost every round. So, my lord, and I'm glad, my lord, I lost because it's fraud. Your lordships, my lord, will grant an order.
Yes.
If your lordships feel that in the interest of justice it's required, your lordships will grant an order. It goes on to say under inherent power, your lordship now grants orders.
Show us those. Because you see what still remains embedded in my mind.
Yes.
Lister and Stubbs, if you remember, 1890, volume 45, Chancery Division.
Yes.
Page 1 at page 11. Right. There's this Lord, what is it, Megary? I can't remember.
I check out.
Yes. Just because it's a plaintiff claims money decree is no ground for restraining the defendant from dealing with his properties.
Then
It's a classical statement. Just look it
Yes.
up once.
Judgment, my lord. That is a
then, my lord,
30th, we are not hearing the appeal. This is just an academic discussion.
I'm just pointing out the judgment that my lord.
the change, my lord, happened from somewhere around 2009. First judgments, my lord, which came said that nowadays it takes a lot of time for grant of a decree. So we have to consider plaintiff can't be left.
2020, there's one Solanki or something.
Yes.
Huh?
Yes.
That is against you
Solanki
also.
traders. That is also against me. But all of it is now undone by Rahul S. Shah,
Which year?
which is, my lord, cited here. It's 2021.
Okay, come back with
And
all
the
this.
court has, my lord, in 5 matters, division bench cases, my lord, held that your lordships are now stepping out. For example, my lord, if it's an admitted claim, even if it's, my lord, even under Order 39, Rule 1B, your lordships are granting injunctions in the nature of, my lord, attachment. Then in case of fraud, under inherent powers. So, my lord, I want to, my lord, show the law on that date.
30th.
Item
हाँ, तो
number
लिखे
4
दीजिए
and
record.
5.
Same order, my
Today's
lord.
paper book. Huh?
Same.
4 and
5.
5 same order?
Great.
না আলাদা একসাথে করবে না, দুটো ফি পাবে না তাহলে ওরা। দুটো অ্যাপ্লিকেশনই ডিসপোজড অফ, হ্যাঁ?
Item number 6.
This is a limited appeal. I am for the appellant. My lord, the only grievance I have is that, my lord, security has been directed by the learned single judge for, my lord, a sum of 129 crores. When the agreement between the parties was the entire amount of assignment of the debt, my lord, will accrue me in my favor. My lord, what had happened is, my learned friend's client had, my lord, taken a loan of about 126 crores. He was unable to repay the loan. The loan amount, my lord, was crystallized later about 129.5 crores. Thereafter, my lord, they said that we are not in a position to make the payment at all. We are going to assign in your favor an arbitral award in a pending arbitration between ourselves and National Highway Authorities of India. Now, my lord, that, my lord, arbitration at that point of time was completely indeterminate. My lord, no, my lord, there was no, my lord, possible
Award that was not there. They will assign that.
No, my lord, they assigned, my lord, the
Fruits.
chosen action.
Shows in action.
The chosen action. And, my lord, ultimately, that award, my lord, resulted in, my lord, a sum of 300, what was it? 100? 322. 322 crores.
In their favor?
In their favor. Now, my lord, the National Highways Authority challenged that award before the Delhi High Court. The Delhi High Court naturally asked, my lord, deposit of the entire sum. 322 crores was deposited. Well, in the meantime, without any notice to our, well, without our knowledge, they withdrew a sum of 49 crores. Well, we came to know of this, we came rushing to court. Well, in the meantime, well, the section 34 application was dismissed. NHAI preferred an appeal before the division bench. Well, while the appeal was pending, we were pursuing our remedy here, well, under section 9. Now, well, then we came to know that, well, they have withdrawn the appeal by settlement of, well, the dispute between the parties. Well, I don't know at what are the terms of settlement. Well, I came up before this court saying that, well, they should not be allowed to withdraw the money deposited in Delhi High Court and walk away with it. They have already withdrawn 49 crores. Well, the learned judge accepted my plea, directed, well, security for a sum of 129 crores. Now, well, the award is, well, for 322 crores, and that is the agreement between the parties. Now, well, ultimately, I may or may not get that amount in arbitration, well, which of course I have now, well, commenced against my learned friend. But, well, the question is, how can the agreement be ignored? Well, and, well, the quantum of the debt, well, therefore be reduced. Well, that is, well, my
No,
short.
what is your claim in the arbitration?
Well, my claim in the arbitration will be for the entire amount of, well, the assigned debt, which is now 322 crores. Well, that is, well, the limited challenge. Now, well, I may or may not succeed before the arbitration, in the arbitration. But, well, the agreement between the parties, well, it will have to be given some sanctity. And the agreement says that the entire, well, awarded amount, well, will be assigned in my favor. Now, well, my apprehension is, well, only this, that, well, today I have a security for about 129 odd crores. Well, I am, well, already, well, made a reference of the disputes to arbitration. Well, if I succeed in the arbitration because of, my lord, the terms of the agreement.
No, but since the arbitration you have initiated already, why don't you approach the
arbitrator
arbitrator?
has not yet been appointed. We have only given a section 21 notice, that is the initiation of arbitration. Well, had the arbitrator been appointed, I would have, my lord, gone under section 17.
Yes.
Well, because the arbitrator had not been appointed, I came under section 9. Well, section 9 order is, my lord, security for 129
Yes,
crores.
the only thing that is troubling my conscience is, will this not be an unjust enrichment? If your claim is 129 crores, yes, we understand there was an agreement for assignment of the shows in action, but 322 crores.
Well, I'll tell you, Lordship, what had happened.
Now there is no 322 because 49 has been withdrawn already.
That's it, 49 withdrawn, but, my lord, naturally,
well, I will be claiming the entire 322 because that is what was assigned in my favor. But I don't have security for the entire 322 now because 49 is withdrawn. Now, my lord, the settlement at 129 crores odd was reached because, my lord, we had then, my lord, because of the complete inability to make payment, had, my lord, at that point of time not, my lord, calculated the interest on the debt. Well, had interest been calculated, my lord, in terms of the loan agreement.
In the section 21, what figure have you mentioned?
Well, at section 21 notice, my lord, I've only referred the disputes to arbitration. My lord, disputes arising out of, my lord, the assignment agreement which contains the arbitration clause.
I see. Where is the impugned order? Let us see.
Well, the impugned order is a part of the memorandum of appeal.
May I just interrupt for
28th April.
Yes.
You have not filed affidavits before the learned singles.
But may I just say this? Lord, I want to file a cross appeal. I'll waive notice of appeal, serve a memorandum of cross appeal within, my lord, 48 hours, and your lordship can, then deal with
No,
it.
no,
because-
what I'm on is that the application is pending before the learned judge.
Yes, that's.
Why don't you go have it thrashed out there?
Well, we can do that. My lord, only thing is, my lord, if your lordship kindly sees just 2 paragraphs of the order. Or, my lord, please see paragraph 12 at, my lord, internal page 10.
Which paragraphs?
My lord, paragraph 12 of the impugned order.
পুরো 322 বলছে এগ্রিমেন্ট ছিল যে
আমাকে যে লিবার্টি
Lord, the 3 issues against, Lord, held against me by the impugned order.
Mr. Chaudhary, nothing has been finally held
Yes.
by this order.
Yes.
That is why we are suggesting you go back, have it thrashed out. This court is always there.
Yes.
Have you filed it? Direction for affidavits was given.
Yes, yes.
Lord, we haven't been able to file it.
1 week, we'll grant 1 week. File it. 1 week, 5 days.
Very well.
Fortnight, liberty to mention before the learned judge, praying for some precedence.
Yes, my lord, only thing is, my lord, your lordship will, my lord, only kindly clarify that, my lord, I shall be entitled to, my lord, pursue my entire reliefs in the section 9 application for single, not limited by the order, my lord, interim order that has been passed. Because interim order is confined to, my lord,
It's because the other prayers have not been rejected as yet.
No, not rejected. But, my lord, if your lordship kindly
At
sees,
interim stage is
my
not
lord, paragraph
binding at the
22.
interim stage.
Correct, correct.
I'm going to ask for dismissal of the petition.
Yes, yes, my learned friend is
We
completely
quite
entitled.
understand that.
My lord, only problem is, my lord, if your lordship kindly just sees paragraph 22.
22.
Well, at about 6 lines from the top of the paragraph, under such circumstances, if the money is withdrawn or if the respondent is paid any money by NHI, which rupees 129 crores shall be invested by the respondent in an auto-renewable interest-bearing fixed deposit in its own name. So,
We
my lord,
will
it's
say that
limited to.
since this impugned order was passed at an interim stage, at the time of final hearing, the petitioner will be at liberty to press all its prayers in the section 9
That's it.
application.
That will suffice. I think.
Anyway, my lord, no
Yes, but-
specific liberty is required.
Sure.
Not that I, my lord, oppose that prayer.
Yes. And the respondent will not be entitled to pray for dismissal.
Let me, I have a.
Yes. This appeal is directed against a judgment and order dated April 28, 2025, which is interim in nature, in the sense that the appellant's application under section 9 of the Arbitration and Conciliation Act, 1996, is still pending before the learned single judge. Paragraph. The appellant has appellant says that it has a huge money claim against the respondent to whom it had lent and advanced substantial sums of money. Stop. The respondent was unable to repay the loan. Stop. An agreement was entered into by and between the appellant and the respondent to the effect that the respondent was assigning the award that it expected to obtain in an arbitration with, your arbitration was with
NHAI.
National Highways Authority of India. Stop. That arbitration culminated in an award of about approximately rupees 322 crore in favor of the present respondent. Stop. The appellant says that if the respondent is allowed to withdraw that entire sum, comma, the appellant will have nothing against which have nothing from which it may recover its dues. Accordingly, comma, the appellant approached the learned single judge with an application under Section 9 of the 1996 Act in view of there being an arbitration clause in the agreement between the appellant and the respondent. Stop. We are also told that the appellant has issued notice under Section 21 of the 1996 Act invoking the arbitration clause. Paragraph. The learned judge has passed an interim order restraining the respondent from
withdrawing anything
beyond 129.
129 crores. Well, that's not really the language of the order. Well, please see paragraph 20.
Has passed a limited interim order.
Yes.
Has limited.
Yes, that's it.
If I get it, I keep it in a fixed deposit, that kind.
The learned judge passed a limited interim order and has directed exchange of affidavits. Stop. Being aggrieved, the appellant is before us. Stop. Paragraph. Since the appellant's application under Section 9 is yet to be considered and disposed of finally, comma, we are not inclined to interfere, comma, at this stage. Stop.
I think that's
Paragraph. Time for the respondent to file affidavit in opposition to the appellant's application under Section 9, petition under Section 9 is extended by a week from date. Stop. The appellant will be at liberty to file its reply thereto, comma, within a week thereafter, or 5 days, or what?
Well, 1 week.
Within a week thereafter, stop. The parties would be at liberty to mention the matter before the learned single judge upon completion of affidavits, and may make a prayer for some precedence. Stop. Paragraph. The appeal and the connected application are disposed of accordingly. Stop. We clarify that we have not addressed the merits of the case at all.
Very good.
Grateful.
Well, the interim order was till 30th of June. Well, directions for affidavits had been given earlier.
Let the interim order, let the interim order that has been passed by the learned single judge continue till the end of July, 2025, or until further order of the learned single judge, whichever is earlier.
Great.
Item number 7.
Well, this is also my appeal. Well, this is a very interesting matter. Well, here, what had happened is, well, the parties in dispute had ultimately entered into a mediation agreement. Well, mediation agreement resulted in the appointment of a mediator. The mediator, my lord, held a meeting of the parties, or held meetings of the parties informally. and ultimately, my lord, reached, my lord, a settlement. Now, my lord, a settlement reached under the mediation, my lord, provisions of the Arbitration Conciliation Act results in, my lord, an award which is enforceable as an award under Section 30 of the Arbitration Conciliation Act.
Just tell me one thing, the Mediation Act has not been...
No, now, my lord, Mediation Act, my lord, saves, my lord, proceedings that had been commenced before the coming into effect of the Mediation Act. That is Section 56 of the Mediation Act. The Mediation Act is an act of 2023.
Has been brought into force. This
Yes,
is what I'm asking.
my lord, not all the provisions, my lord, partially, my lord, given effect. Partially, my lord, brought into force. Now, my lord, what, my lord, we had done is, my lord, we had started this mediation under the provisions of the Arbitration Act. My lord, it's called conciliation under the Arbitration Act, but now it has been clarified that mediation and conciliation are the same thing. Well, that is Section 3 of the Mediation Act itself, which clarifies that mediation and conciliation are one and the same. Now, my lord, mediation agreement, followed by mediation, followed by a, my lord, settlement agreement under the mediation signed by the parties, signed by the, my lord, mediator. Well, this under Section 73, subsection 3 and 74 of the Arbitration Conciliation Act, well, it results in an award. Well, we had then, my lord, filed an application seeking execution of the award because, my lord, there was no, my lord, challenge.
What kind of an award? Money?
Yes, my lord. It's money, land, transfer of, my lord, shares, various things. My lord, there was, in fact, my lord, a separation of, my lord, two business entities. My lord, some, my lord, exchange of properties, exchange of shares, in, my lord, discharge of debts, and, my lord, other, my lord, things. So, my lord, there was a composite, my lord, settlement agreement signed by the parties, which we, my lord, said amounts to an award, enforceable as an award passed under Section 30 of the Arbitration Conciliation Act. My lord, we filed for execution. Now, my lord, that document, my lord, the settlement agreement contained one arbitration provision also. My lord, which, my lord, provision was, my lord, for, my lord, those disputes which had not clearly, my lord, been settled in mediation. Well, it is disputes arising out of the settlement agreement that were to be mediated, not, my lord, the original disputes which had been referred to mediation. The learned single judge was pleased to hold, my lord, that because of the presence of the mediation of the resolution of dispute provision, in that, my lord, this is not an award, and, my lord, hence cannot be executed as an award. Well, that is, my lord, the question. Now, my lord, the question that, my lord, will fall for your lordship's consideration here is, my lord, what would be the effect of, my lord, a mediation agreement, my lord, before the coming into force of the Mediation Act? My lord, today, my lord, how would be the agreement or the mediation settlement document, my lord, which is also really an agreement between the parties, be construed? My lord, particularly when there are previous and succeeding clauses, that is before and after the resolution of disputes provision, which provides unambiguously that all disputes, my lord, that have been settled under this agreement have been settled fully and finally. And, my lord, whether, my lord, in such circumstances, my lord, I shall be deprived of the fruits of mediation. Now, my lord, amongst other things, in the course of mediation, the parties had deposited original title deeds with the mediator. And, my lord, amongst, my lord, to secure the money claims, my lord, of the disputes in mediation, a sum of 20 crores of rupees. There are, of course, other money claims also. But, my lord, we had asked for immediate release of that money because, my lord, under the mediation agreement, my lord, what we have given away are the shares of our company. We have parted with our company. We have given our lands. So, my lord, we have given our business. My lord, we are supposed to receive, my lord, certain parcels of land where, my lord, we are supposed to, my lord, start our alternate business. We are supposed to receive the money. My lord, that is consideration.
Your execution application has been dismissed.
Yes.
We'll hear out the appeal any day you tell us. If all papers are before us.
All papers are there in the, my lord, stay application.
There is just one preliminary objection, my lord, whether this is an
Objection to the maintainability of the appeal.
because this is possibly not something which falls under Section 13 or Order 43.
I anticipated this. My lord, I am ready with this because, my lord, ultimately, my lord, the order passed in execution. Yes. But, my lord, the order unsettles an award, what we call an award. So, my lord, it is really, my lord, setting aside of an award.
Save your objection for the next day.
I have 2 division bench judgments, my lord.
Save your objection for the next day when we take up the appeal. Right?
Well, as whenever your lordship.
Any day you tell us.
Monday.
Next Monday. Next Monday.
Next Monday, 23rd.
Led by Mr. Rudraman Bhattacharya.
He's today morning he has been, yes, 103 fever, and it has been predicted that it may be COVID. Maybe.
No, so what? Tell us what to do then.
Should be Monday. Lottery only keeps it next Monday.
Next Monday.
They are apprehending that Mr. Bhattacharya might have contracted COVID.
Well, Mr. Bhattacharya is now an expert at appearing online. If with your lordship's leave, my lord, he can. Well, I'll tell your lordship what my apprehension
We are
is.
keeping it on Monday.
Yes,
We are
great.
keeping it on Monday.
Well, let my lord status quo be maintained, because I'll tell your lordship why. My lord, they have since given us notices, which are part of my lord the stay application before your lordship, that my lord they will discontinue my lord the business that has been transferred to us under the agreement, my lord, with a third party. Because my lord, there are tankers that are established in the property.
So since we propose to hear out the appeal, do not take anything, do not do anything.
We will not take any steps, but kindly do not record any order as of.
If you are saying so, we have full,
Very well.
yes.
Very well, my lord. That is good enough.
Yes.
Lawyers, my lord, undertaking to court,
Yes.
that is good enough.
Yes.
No,
And now,
not 7 days, my lord. They have assured us more.
Yes,
Your
till
lordship.
next Monday, we will not take any steps.
till next Monday, yes. Till the next date of hearing.
But kindly do not record.
It's already recorded on YouTube. This appeal, এই কিছু কি দাওনি তো মেমোটা দাও। This appeal is directed. Mr. Chaudhary is appearing.
Yes, Mr. Shobhojani Chaudhary appeared.
But I'm not sure.
This appeal is directed against a judgment and order dated May 20, 2025, whereby the execution application of the appellants being EC Com 9 of 2025 was dismissed by a learned judge of this court. Paragraph. In short, the material facts appear to be that business disputes arose between the parties here too. Stop. The parties entered into a mediation agreement. Stop. A settlement agreement was arrived at before the mediator, duly signed by the.
Our case is that no settlement agreement was.
No,
very well, very well. According to the appellants, a settlement agreement was arrived at before the mediator. Appellants, a settlement agreement was arrived at before the mediator. Stop. The same is deemed to be an award under the Arbitration and Conciliation Act, 1996. Stop. Accordingly, the appellants put the award in execution by filing the aforesaid execution application. Stop. Paragraph. It appears that the settlement agreement contained a clause for resolution of disputes arising out of the settlement agreement through mediation.
No.
Through arbitration. Through arbitration. Stop. Noting the same, the learned single judge has held that in view of such clause, no final award can be said to be in existence which can be enforced by way of execution. Stop. Accordingly, the appellant's application was dismissed. Stop. Hence this appeal. Paragraph. We propose to hear out the appeal. Stop. We are told that all papers that were available before the learned single judge are before us as annexures to the stay petition. Stop. The stay petition shall be treated as an informal paper book. Stop. All formalities are dispensed with. You represent all the respondents?
No. 1, 2, 3, and 6.
What about the others?
We have. They had not appeared before the single judge also. We have served all of them.
Anyway, serve one more notice that. কি বললাম? Dispensed with. Stop. Since the respondent numbers
1, 2, 3, and 6.
1, 2, 3, and 6 are represented through learned counsel, notice of appeal is deemed to be waived by those respondents. Stop. Let the appellants serve a notice on the other respondents notifying that this appeal will be listed for hearing on সামনে সোমবারের ডেটটা দিয়ে দাও under the appropriate heading amongst the first three items. Stop. Paragraph. Learned advocate for the appearing respondents takes a point of maintainability of the appeal. Stop. The same shall be considered on the next date. Paragraph. The stay application stands disposed of.
Grateful.
Leave to file the certificate copy.
Well, I'm praying for leave to file the certified copy because filed without certified copy.
File.
I'll hand it up to your lordship.
Leave is granted to the appellants to file the certified copy of the impugned order in court today. Affidavit of service filed in court be kept with the records.
Appeal from order, item number 8.
My lord, in this matter, my lord, I'm led by my senior learned counsel, it's Devnath Ghosh, my lord, and he is engaged in court number 41. I'm praying just pass over, my lord. Short pass over.
Not a problem. I have a matter fixed.
Pass over, my lord.
Not today.
My lord, short pass over, I'm just praying. I'm just praying short pass over, my lord. He's appearing in court number 41, my lord.
No, I won't come in the way.
Isn't he your chamber junior?
But that should be a good ground to oppose and oppose very hard.
What do we do? Tell us.
No, makes it not today.
Not today.
12 o'clock, I have a different matter fixed. Oh, my lord, would your lordship will hear me first? Your lordship was hearing me. I'm the appellant.
We were hearing you.
Yes, your lord. Oh, different bench. Sorry, my lord. I'm very sorry, my lord. The bench has changed, my lord. So it'll have to start afresh.
Yes.
But in that case, my lord, keep it not tomorrow. No, my lord, not today.
Not today, whatever that means. Not today. এই আগের ম্যাটারটা স্টে অ্যাপ্লিকেশনে ডিসপোজড অফ হয়ে গেল, কিন্তু আবার ট্রিটেড অ্যাজ
And not to that.
Appeal from degree, item number 9.
9 টা সিটা কি আছে?
Oh, no, sorry. Item number 10.
My lord, this is my appeal, my lord, from an order of 10th September 2024.
You are for the respondent?
I'm for the respondent plaintiff.
My lord, this is an appeal, my lord, against an order passed under Order 12, Rule 6. My lord, may I, before going to the facts, my lord, my grievances against the order are mainly twofold, my lord. My lord, here a judgment on admission has been passed in a case where the documents are disputed and there are serious disputed questions of fact. And secondly, I have raised this question of law, argued it. It's a part of my written notes of argument, but this question has not been decided or considered in the impugned order. Now, my lord,
or মেমোটা দাও, sir. Just because you have put in something in your written note does not mean that you necessarily argued that point before the learned.
My lord, it is also my pleaded case in my objection written.
Even then, we will go by what the learned judge has. If you have a grievance that your case has not been considered, go back with a review petition or any other petition as is. We will go by whatever is recorded in the order. That is the law. কোথায়?
But the impugned order is just page 237.
We'll see it from the memorandum. Allow us to go through it.
Could I take your lordship's leave for 5 minutes, my lord? Could I take your lordship's leave for 5 minutes, your lordship? Could I take your lordship's leave?
Yes, my lord. My lord, here, my lord, the judgment on admission has been filed in a case, my lord, where goods have been supplied. My lord, will kindly come to the impugn order once, my lord. May I show it from the order first? The goods have been supplied are crash barriers. Now, my lord, crash barriers are barriers put between a road where there is two-way traffic or at the edge of the roads. They are instruments to prevent accidents. So they have to be made and supplied as per certain specifications depending on the road, my lord. My lord, it is the admitted case of the plaintiff. I am the defendant, my lord. It is the admitted case of the plaintiff and is also reflected in the impugn order that the goods were to be supplied at certain specifications and the payment was to be made only if the goods were supplied as per those specifications. My lord, will kindly come to page 238 of the impugn order, my lord.
How do you explain the 4th January letter?
Yes, my lord. My lord, the 4th January letter.
Where is it? 4th January letter, let us see.
That is in page 35, volume 1, my lord.
Dauto.
Yes, my lord. My lord, may I just show one document, my lord, for which this genesis of this document will be clear, my lord. Page 76, my lord, will kindly take up.
76.
Yes, my lord. This volume only.
Yes.
My lord, what has happened is the goods that were supplied to me were not as per specifications, and therefore I had not made payment. In fact, my lord, although the goods were supplied in 2021 till June 2022, there was not a single demand from them. In retaliation, what they did is they stopped supply to me. Therefore, my lord, I had approached this person, Vishal Agarwal. He's the same person who has affirmed the plaint, my lord. He is the chief manager of sales and marketing, and have approached him on 4th January 2022 for resuming supply, albeit through a different entity also owned by me. Now, my lord will kindly see the letter and see the number 2520,606.30. This is the exact number, my lord, that appears in the 4th January letter. There is no explanation as how the 4th January letter was served by me upon them. There's no envelope, there's no service record. This is how it was done. 2520,606.30. Nahi chalega ye letter. And then thereafter I sent another letter, which is also sent on 4th January 2022. And thereafter, my lord will find that I have been able to place an order via Infratech Engineering Industry and got supply from them, my lord. But my lord, my main grievance, my lord, is that my argument that the goods were to be supplied as per specifications that were not considered, my lord, which in my reciprocal submission is a question of fact, which goes to the roots of the matter.
Which correspondence have you raised this issue? Sure.
Yes, my lord. May I first show Order 12 rule, their application under Order 12 Rule 6, my lord. This is the pleaded and admitted
Show us
case.
your document, some correspondence where you have said that the goods you have supplied are not as per the contractual specifications.
My lord, this is there in the WhatsApp conversation, my lord, that I just showed.
WhatsApp conversation.
Yes, my lord. My lord,
Not a single letter completing
my
of.
lord, this entire transaction has taken place through verbally, and the purchase order is also verbal. That is also admitted, my lord. They also have not made any demand prior to June 2022, although the supply was made in 2021 March. My lord, whatever correspondence was happening, it was happening verbally at both ends, my lord. My lord, one more point, if I may bring to my lord's notice, my lord. My lord, they have relied upon 2 documents to show that there is a clear and unambiguous admission, my lord. First is the letter, my lord, which in my submission was specifically given to them and at a with a number that they have suggested. If my lord will kindly take, I'm so sorry.
No.
My lord will kindly see the letter. It says that the amount appearing in the letter is based on a ledger. We will clear the pending amount. The amount is the exact replica of what was there in the WhatsApp, lying in the ledger of Utkarsh India Limited. No ledger was been given. No ledger, in fact, has been annexed in the plaint itself. There is no record that this is the amount. The only record that this is the amount due is in the WhatsApp. And my lord, apart from that, another question that I had raised is that this is a conditional admission, because if my lord will kindly look at the second paragraph, in between any requirement of the materials, we will lift those with the payment. At the time of lifting, please cooperate with us to revive the situation. This, my lord, read with the WhatsApp conversation, clearly, my lord, in my reciprocal submission indicates that this was not a letter that was given voluntarily. This was a letter given for me to resume getting supplies from the plaintiff. And my lord, secondly, there's another document which they have relied upon, which is a check of 7.50 lakhs. This they contend that the fact that I have given them the check is in pursuance of a negotiation and discussion that had taken place, whereby a full and final settlement had been reached. Now, my lord will kindly see the timeline of the events that has happened here, which will show the malafide. My lord, the check is dated 23rd August 2022. If my lord kindly takes a page 42, the check is there. The check is then deposited on 29th August 2022. No intimation to me. The check is dishonored.
Where is the requirement in law that once you issue a check, upon deposit, I have to tell you that I have deposited?
I bow down to them, but my lord, my case is this is a security check that I had given to them. And they have intimated that the check, that my lord will kindly take up the email once, my lord, page 41. My lord, this will...
Yes.
Yes, my lord. The email from Vishal Agarwal, again the same person, my lord, with whom the WhatsApp conversation took place, sent 31st August 2022. Subject mutual settlement. Respected sir, we have received a check of 7.50 lakhs, a VDA check number such and such, dated 23rd August 2022 of ICICI Bank, being part payment against the full and final settlement agreed between both of us. Well, the intimation of this purported full and final settlement is coming on 31st August, which is the same date on which the check gets dishonored. Well, this is a security check.
Why did it get dishonored?
Well, due to funds insufficient, my lord. This was a check given to them long back as a security check, because admittedly there was a running and continuous account between these two parties.
Very well.
My lord, may I just trouble my lord with only one paragraph? My lord will kindly come to the order 12 rule application. Only one paragraph. It is at page 5, my lord. My lord, the page 5, it starts at page 6.
Yes.
My lord will kindly note para 1, 2, 3, and 4. Only these terms that the petitioner is inter alia engaged in the business of manufacture and sale of steel structure, crash barriers, steel, ERW pipes, polymer products of diverse specifications. Now, my lord, in para 3, my lord will see the first line. The respondent was aware that the petitioner manufactures crash barriers of diverse specifications. And in para 4, my lord, where the negotiation between the understanding between the parties is written, negotiations ensued between the parties, and it was inter alia agreed that the respondent would place verbal purchase orders. There's nothing in writing as to what the specification will be, from time to time indicating requirements, and the petitioner would thereafter effect supply of goods to the respondent in terms of requirements. Malad, in my respectful submission, Malad, this goes to the roots of the matter, because if it finally I am able to prove that the goods, whatever they have supplied to me, is not as per the specifications, Malad, my liability to pay does not arise. And this is a point that I had raised in my written objection and in my written notes. This point has not been considered at all in the impugned order.
Thank you. Ishu. This is good. Why are you standing up? This judgment, this appeal is directed against a judgment and order dated September 10, 2024, whereby the respondent's application for judgment upon admission to the tune of rupees 25,20,606 was allowed by a learned judge of this court, along with interest at the rate of 18% per annum from May 1, 2021 till realization of the principal amount. Paragraph. The brief relevant facts of the case are that the respondent oblique plaintiff is engaged in, inter alia, the business of manufacture and sale of steel structures, crash barriers, steel ERW pipes, etc., of diverse specifications. Stop. The appellant oblique defendant is engaged in the manufacture and sale of construction equipments, including crash barriers of diverse specifications. Stop. Paragraph. It appears that pursuant to negotiation, an agreement oblique arrangement was arrived at between the parties hereto for supply of crash barriers along with allied accessories by the plaintiff to the defendant as per the verbal purchase orders placed by the defendant on the plaintiff. Stop. It further appears that the defendant placed several orders on the plaintiff and received supply of the relevant products. Stop. The parties appear to have maintained a running and continuous account. Stop. Payments, ad hoc payments were made from time to time by the defendant to the plaintiff, which were adjusted in the running accounts. Stop. Next. It appears that on April 23, 2021, the defendant paid a sum of rupees 8.50 lakh to the plaintiff. Stop. Out of the said sum, an amount of rupees 12,195 was adjusted against the pending dues of the plaintiff, and the balance rupees 8,37,805 was adjusted against 4 invoices raised by the plaintiff on the defendant during March-April 2021. Stop. Thereafter, after such adjustment, a sum of rupees 25,20,606 remained due and payable by the defendant to the plaintiff. Paragraph. The plaintiff claimed the outstanding amount. Stop. The defendant issued a communication dated January 4, 2022. Stop. This communication is important as the same forms the fulcrum, F-U-L-C-R-U-M, fulcrum of the plaintiff's prayer for judgment upon admission. Stop. The communication reads thus, colon diye, page 35, sir, you said page 35.
Yes, yes, my lord.
Page 35 is এটা আছে, set out করে দিও। Paragraph. In spite of the aforesaid communication, nothing was paid by the defendant. Stop. The plaintiff sent reminder emails on June 22 and June 25, 2022. Stop. On July 6, 2022, the plaintiffs sent a legal notice to the defendant, which the latter duly received. Stop. However, no further payment was made by the defendant. Stop. Paragraph. According to the plaintiff, on August 5, 2022, the defendant approached the plaintiff with a proposal to settle the disputes amicably. Stop. According to the plaintiff, it was decided that the defendant will pay the sum of rupees 27,50,000 in full and final settlement of the plaintiff's claim, in 2 installments within September 15, 2022. Stop. The defendant issued a check for rupees 7.50 lakh, dated August 23, 2022, and apparently assured the plaintiff that another check for the balance amount would be issued within September 15, 2022. Stop. The check for rupees 7.50 lakh, when presented for payment, was dishonored by reason of there being insufficient funds in the concerned bank account. Paragraph. In the aforesaid factual matrix, the plaintiff has instituted the present suit. Stop. In the suit, the plaintiff took out an application under Order 12, Rule 6 of the Code of Civil Procedure for judgment upon admission to the tune of rupees 25,20,606. Stop. Paragraph. The learned single judge noted the rival contentions of the parties in great detail. Stop. The learned judge considered the legal precedents cited on behalf of both the parties. Stop. His lordship came to the conclusion that there was a clear and unequivocal admission of liability to the tune of rupees 25,20,606 in the defendant's letter dated January 4, 2022. Stop. Accordingly, the learned judge allowed the plaintiff's application. Stop. Hence this appeal at the instance of the defendant. Paragraph. Learned counsel appearing for the appellant oblique defendant argued that the letter dated January 4, 2022, cannot be considered to be an unequivocal admission of liability by the defendant. Stop. The defendant had issued that communication only to persuade the plaintiff not to stop supplies to the defendant. Stop. In fact, the supplies made by the plaintiff earlier were not as per specifications, by reason of which the defendant has suffered huge loss and damage. Stop. Exchange of WhatsApp messages would show that the letter dated January 4, 2022 was not meant to be an admission of the defendant's liability. Stop. If the learned single judges now, several tribal issues have been raised by the defendant, and unless the order under appeal is set aside or stayed immediately, the defendant shall suffer irreparable loss and prejudice. Paragraph. We have not called upon the respondent to make submission. Paragraph. We find no apparent infirmity in the order under appeal. Stop. The authenticity of the letter dated January 4, 2022, emanating from the defendant, is not disputed by the defendant. Stop. The defendant attempts to offer an explanation as to why the letter was issued, which is not acceptable to us. Stop. As regards the defendant's contention that the plaintiff supplied defective goods to the defendant, we do not find any contemporaneous document on record to that effect. Stop. If indeed the plaintiff failed in its contractual obligations vis-a-vis the defendant, comma, nothing stopped the defendant from recording the same by issuing appropriate letter, stop. The defendant should not have, in that event, comma, issued the admission letter dated January 4, 2022, comma, nor should it have issued the check for rupees 7.50 lakh in favor of the plaintiff. Stop. Paragraph, on an overall consideration of the facts of the case and the documents on record, comma, we have no doubt in our mind that the communication dated January 4, 2022 amounts to a clear and unequivocal admission of liability by the defendant to the tune of rupees 25,20,606. Stop. Paragraph. The provision of Order 12, rules, Order 12, Rule 6, 6 of the Code of Civil Procedure has been promulgated by the Parliament to enable plaintiffs with genuine genuine and undisputed claims, to recover their dues without going through an unduly long process of trial of the suit. Stop. If now in a case where the defendant has admitted its liability, comma, it would indeed be unfair to subject the plaintiff to a long process of trial. Stop. The purported defense sought to be raised by the present defendant appears to be moonshine and an attempt in desperation. Stop. Paragraph. We do not find any reason to interfere with the judgment and order under appeal. Stop. The learned judge has rightly appreciated the scope of Order 12, Rule 6 of CPC and has rightly allowed the plaintiff's application. Paragraph. In view of the aforesaid, comma, this appeal stands dismissed along with the connected application. Is there any application? No.
No,
No,
the
Bala.
stay was disposed of
Oh,
previously.
stands dismissed with costs assessed at rupees 10,000 to be paid by the defendant, by the appellant. এই ওটা কাকে দেওয়া হয় জানো? High Court Legal Service Authority. Huh? কাকে দেবো?
Ballot will kindly not impose costs, Ballot.
Why? Good cause.
No,
Good cause.
there was a grievance, Ballot. Ballot are rejected. Kindly will not impose costs.
দিও
I'm
না।
humbly praying,
আপনি
Ballot.
অত হেসে হেসে বলছেন দিও না, ছেড়ে দাও। There will be no order as to costs.
I'm so grateful. Grateful, Ballot.
When were you, what is the year of your enrollment?
Ballot, I was enrolled in 2020, Ballot.
2020. You have done well, but you have got a totally meritless case. What can you do?
Grateful, Ballot. Great. I'm so grateful.
উঠবো
Item number 11.
This is my appeal, Miller, arising out of an order, Miller, whereby the suit has been dismissed, Miller, on the ground of Section 12A, Miller, of Miller, the Commercial Courts Act. Miller, the ground taken by my learned Judge Miller is A, Miller. The Miller's knowledge was January. The suit was filed in October. So, Miller, there was no earth-shaking urgency, Miller, for Miller filing the suit.
Passing off.
Passing off action, Miller. Miller, there is no case of Miller falsity or deception pleaded in the plaint, Miller, or made out in the plaint. What is there, Miller, that was stated, and Miller, on the ground of delay, it has been, Miller, rejected. Miller, pleadings were there, paragraph 93 and 97. That's a recurring cause of action. Every sale, Miller, gives a fresh cause of action. Miller, it's not a case, Miller, the plaintiff has said, Miller, some, Miller, misstatement to get out of 12A, Miller. Something knowledge was in 2018 or 2017. He has suppressed and, Miller, he has filed. It is not a case of such. So within the limited window, Miller, of Miller, Jamini Monohar, Miller, the plaint could have been rejected, non-suiting the plaintiff in question. Miller, in a passing of an infringement suit, Miller, courts have held after Jamini Monohar, the subject matter has to be seen, the cause of action has to be seen, and it's on the Judge Miller, Honorable Judge Miller, who is taking up the matter, Miller. It's the discretion of the Judge Miller to give me that window, Miller, not to give that window. Now, Miller, when the plaint was moved, Miller, in October, Miller, ex parte stage, when we moved the plaint, the order records, Miller, knowledge January. It's a recurring cause of action. Miller and Miller, suit has been filed now. Products are identical. Hence, Miller, injunction was granted. So, Miller, this was within the knowledge of Miller, the honorable single judge Miller, of the different honorable judge was taking, that Miller, knowledge and Miller, the cause of action of file and the date of filing of the suit. It's a recurring cause of action. He granted that leave. Miller, after that, Miller, on Miller, the application, Miller, in the month of April, Miller, the plaint has been rejected. May I show, Miller? There are certain, Miller, observation as against me in the order also. Lordship will kindly take, Miller.
Impugned order.
Yes, impugned order.
6th May.
6th May. Kindly have a look at, Miller, the order of 6th May. Miller, this is an application seeking revocation of dispensation granted to the plaintiff without exhausting the remedy of pre-suit mediation and settlement under 12A of the Commercial Court Act. Briefly, the plaintiff is inter alia engaged in the manufacture and distributorship of plastic pipes and machine tools that were sold by the plaintiff under the mark Pankaj Flex. In addition, there are different trademarks, Pankaj Flex, Pankaj Flexi, Pankaj, all which have been assigned to the plaintiff. The full particulars of the mark registered with the plaintiff has been enumerated in the plaint. In the suit, it is alleged that the defendant has adopted a deceptively similar mark, Polypankaj, to ride on the goodwill of the plaintiff and to create confusion insofar as the source of the goods are concerned in such suits for infringement and passing on. The relevant pleadings in obtaining dispensation under Section 12A are set out below. Miller, I am placing it from here, Miller, so I don't place from the plaint. The cause of action of the instant suit arose for the first time in January 2024. It was on that date, Miller, the defendant, Miller, the plaintiff had filed an application for rectification. So that is the knowledge, Miller. I have pleaded the knowledge. I had filed a rectification for expunging the defendant's mark. My marks are not under challenge, Miller.
Polypankaj was also registered mark.
Polypankaj, defendant got is registered as proposed to be used with a filing of February 2023. As proposed to be used. My user is 1976. When the plaintiff came to know, defendant started flooding the market with the impugned products under the mark Polypankaj, and the same is continuing day to day. The cause of action of the plaintiff as against the defendant are for infringement of the plaintiff's registered trademark Pankaj and passing off by the reasons of the use of the mark Polypankaj, and also for infringement of the registered copyright of the plaintiff. Such causes of action as against the defendants are recurring in nature, and every sale of goods by the defendant under the mark Polypankaj gives rise to fresh cause of action to the plaintiffs to sue for infringement and passing off. Such cause of action has arisen within and outside the jurisdiction aforesaid. Hence, there is no delay on the part of the plaintiff in filing the present suit, and on the part of the plaintiff's claim being barred by laws of limitation. Para 98, the Honorable Judge has quoted, the instant suit for infringement and passing off contemplates urgent relief to protect the interest of the plaintiff. The Trademark Act 1999 makes it abundantly clear that This is the option of the plaintiff to seek urgent relief. The defendant has obtained registration of the mark Polypankaj, intimating the same color combination of the artistic work which has been adopted by the plaintiff, and the mark appears to have been registered on 3rd December 2023. Similar the suit 3rd December 2023, rectification on 4th of January 2024. The parties are already litigating over its right in respect to registrability of the defendant's mark Polypankaj before the trademark registry, wherein it is a specific case that the plaintiff's impugned mark Polypankaj is devoid of distinctive character and is not capable of distinguishing the goods of defendant from those of the others. Furthermore, it is a specific case of the plaintiff. The defendant's purported mark Polypankaj is identical to the plaintiff's prior mark Pankaj and used in respect of similar goods covered by the mark, and there exists a likelihood confusion on the part of the public by adopting the impugned mark Polypankaj, as a defendant is seeking to wrongfully seek an association with the plaintiff and the mark Pankaj. There is bad faith involved on the part of the defendant in applying for and obtaining registration of the mark Polypankaj despite being fully aware of the plaintiff mark Pankaj. Every sale of goods by the defendant under the impugned mark gives rise to a fresh cause of action for the plaintiff to sue for infringement of copyright, trademark, and passing out. In such circumstances, there is no possibility of pre-suit mediation. The plaintiff is beseeching this on dispense with the provisions of Section 12A of the Commercial Code Act, considering the defendants has not only adopted an identical or deceptively similar mark as the plaintiff marks while adopting a slavish imitation of the artistic work of the plaintiff sold and distributed under the mark Pankaj by the plaintiff reasonably believes that an attempt for a pre-suit mediation and settlement of disputes would be an ideal formality. Why, Millard? Because, Millard, A, it's a recurring cause of action. Millard, Lordship knows in trademarks matter, delay, it's by itself is not. If delay is coupled with something like an acquiescence, like a suppression, like a deceit, like Millard suppressing deliberate facts, Millard, like knowledge parties are litigating from 2016, Millard, I say immediately I have come to know the limited window of time. And Millard, parties are already before the trademark registries, before a mark in question, Millard, before this particular mark in question. In this case, Millard, whether Millard the rigors of 12A of the Commercial Codes Act will be dispensed with or not. It's not a question of leave like Section 80 subsection 2. It's a question of dispensation. Without Millard taking recourse to mediation, can I file a suit or not? Because filing of the suit is not a bar under Section 9 of Civil Procedure Code. It's a case of postponement by right. Seeing the product in question, whether Millard, the Honorable Single Judge who had granted an order, Millard was perhaps within his jurisdiction, to grant me the dispensation. Now, Millard, kindly take. Upon filing of the suit by an order dated 20th September 2024, the plaintiff obtained leave under Clause 12 of the latest patent, order to Rule 2 of this Code of Civil Procedure, and dispensation of the requirement of the 12A of the Commercial Code Act. Thereafter, there has been diverse interlocutory proceedings which have been filed by both the parties. So, it is recorded that he has given the leave. On behalf of the defendant, it is contended that there are no grounds pleaded to dispense with the requirement of 12A of the Act. Millard, grounds I have shown, Millard. What is the case, Millard? No falsity I have alleged. It is alleged that the plaintiff came to learn of the impugned products being sold in the market for the first time in January 2024. Upon making inquiries, the plaintiff ascertained the impugned mark has been registered on 3rd December, it should be 23rd December 2023. Accordingly, the plaintiff had filed an application for rectification on 4th January 2024. Millard, I cannot, Millard, get out of that. That's my knowledge. So I file it, his rectification. The suit has been instituted on 20th September 2024. There is no explanation whatsoever kind as to why the plaintiff waited approximately 9 months for filing the suit. The averments in question, dispensation of 12A of the Act, has been created as general, vague, insufficient for dispensation to be granted. Now, Millard, I just pause here for a moment. Millard, in a coordinate jurisdiction, Millard, there is a finding, Millard. I had showed that January is the knowledge. I am filing the suit today. You give me an order. He has granted that order. That order has not been challenged. Of course, it's an ex parte. It's not a case, Millard, that I had said, Millard, September or something. The defendant comes forward and say, no, this is not September. This has happened long back. So, Millard, whatever we show to the court on the first day, the court grants order on such basis. So, Millard, the situation, Millard, didn't change. I'll show that order on question also. Millard, in support of the contention, reliance have been placed on the judgment of Patil Automation, Rakeja Engineering, and KD Kirit, and Protective such and such, and Unique, and also the judgment of SRMB and Indian Explosive. So these are the judgments cited by the defendant, and also an unreported judgment of Pranoy Shah versus Robindra Narayan Shah. Now, if your lordship takes Patil Millard is not a case of Millard passing off or infringement Millard or intellectual property. Millard, Jamini Monor is a case of intellectual property where lordship will find that paragraph 10 and 11 are there, the limited window, but the suit was ultimately not rejected. The order 7, rule 11 was dismissed. So far as Millard, protractive shipping is Millard and admiralty. Millard, unique Millard was a case of falsity and deception, which we are arguing, Millard. Millard, I had argued that matter. And SRMB BS Sponge was Millard a delay of 4 years in question, which was there in the plaintiff itself. Now, Millard, kindly take Millard on behalf of the plaintiff. It is contended that absence of fraud, deception or misrepresentation, there is no power to revoke under 12 capital A of the Act. That is Millard exactly the language of Jamini Monarch. In any event, the plaint has to be read holistically from the standpoint of the plaintiff. It is submitted in the matters pertaining to intellectual property. Urgency for reliefs arises from the very nature of the subject matter, and dispensation ought to be granted as a matter of course. In support of the contention, defendant Millard, this is my submission, it should be plaintiff Millard. It can't be defendant here Millard, because I am submitting Millard. Defendant relied upon the decision of Jamini Manohar, Srishti Infrastructure, which says Millard, plaint should not be dismissed Millard, relying Millard. Sarga Hotels, Kohinoor Feeds versus Veda, where Millard, the division bench of Telangana High Court said subject matter and the products have to be seen prior to exercising this harsh right Millard. Millard, Chemco Plastics, where Millard goes on the recurring cause of action, different attributes are there. Then Millard, Quality Service, and Bombay's and Lala Bhagwan Das is on the question of Millard binding precedent. This I cited. This is defendant, it says, but it's part of my note. It's the plaintiff who has cited all these judgments. Because it's my submission. Naturally, Millard, it should be me. It's part of my note. Lordship can take it from me. Significantly, Millard, this is significantly. Now, Millard, this is I was arguing in the court below. Significantly, the plaintiff chose to surreptitiously include in the notes of submission case laws which has neither been cited or referred during the hearing of the application, in addition to a plea which has not been raised that a coordinate bench should not hear the matter of dispensation granted by a man which is inserted in the notes of argument. Millard, this is part of entirety of my judgments of the notes of arguments. I have filed a notes of arguments. Matter was going on. The Honorable Single Judge said, Millard, that please keep your notes ready. I kept the notes ready. I have filed my notes on the date of closing. Now, if I have cited this judgment, Millard, on the date, Millard, when the judgment of, if the learned judge records in the preceding paragraph that I have cited this judgment, it's recorded as a defendant. Defendant can't cite. These are the plaintiff's cases where the suit cannot be dismissed. Millard, if I have cited this judgment, how Millard have surreptitiously included in the notes in question? Now, Millard, Lordship knows, Millard, in that matter of Millard MSME, the Supreme Court, I was saying, Millard, there are 3 or 4 Supreme Courts in line. Now, which is binding? There are garden-rich shipbuilders. Naturally, as a counsel, I have to say, Millard, this is the division bench in Srishti. This is the division bench in SRM. There are 2 contrary division bench in question. One of the single judges already in this matter has taken this view in this question. Look, whether it's a case, Millard, of trying to avoid that court in question. I have made that same argument before the division bench also, showing these are the A, B, C, D, E, F, G, H of the Supreme Court. One is a 2 bench, one is a, what is the binding effect? In fact, this fell from the bench, Millard, that the first in line will prevail. So, Millard, if I have cited, Millard, these judgments which is recorded, where is the question of surreptitiously including in the note, Millard, these judgments in question? Now, Millard, kindly 12A is quoted. I am not, Millard, troubling your Lordship, Millard. 12A is quoted, Millard. Unless, Millard, it's mandate. Now, Millard, kindly take Jamini Manohar is quoted. I, Millard, place Jamini Manohar from here. We are of the opinion then when the plate is filed under the Commercial Courts Act with a prayer for urgent relief, the commercial court should examine the nature and subject matter of the suit and the cause of action and the prayer for interim relief. So, my lord, when the suit is filed, Jamini Monor itself is saying that what should be examined is the subject matter of the suit, cause of action, and the prayer for interim relief. So, my lord, if there's an examination, same yardstick cannot apply for a money suit or for an invocation of restraining invocation of bank guarantee or trademark, or my lord, any other suits where the principal object is my lord, a perpetual injunction, principal relief. So that is exactly what is said. The prayer for urgent relief should not be a disguise or mask to wiggle out or get over 12A of the Commercial Courts Act. The facts and circumstances have to be considered holistically from the standpoint of the plaintiff. My lord, may I pause here? If my lord, lordship considers holistically from the standpoint of the plaintiff, my lord, if the marks are identical, the get-ups are identical, there is already a cancellation petition. Is, my lord, the question is very short. Is paragraph 93 and 97, my lord, which is a recurring cause of action based on is enough for dispensation? When, my lord, I have got an interim order on the basis of an identical package shown and the trial court, my lord, records that is January 2024. Non-grant of interim relief, may I continue? Non-grant of interim relief with the ad interim stage when the plaintiff is taken up for registration and administration examination will not justify dismissal of the commercial suit under Order 7, Rule 11 of the Code. At times, interim relief is granted after issuance of notice. Nor a suit can be dismissed under Order 7, Rule 11 of the Code because the interim relief post argument is denied on merits and examination of three principles, namely prima facie case, irreparable harm and injury, balance of convenience. The fact that the court issued notice and granted interim stay may indicate that the court is inclined to entertain the plaint. Having stated so, this is the rider, my lord, which is only put, my lord. Having stated so, it is difficult to agree with the proposition that the plaintiff has the absolute choice and a right to paralyze the section 12A of the Commercial Court Act by making a prayer for urgent relief. Camouflage and guise to bypass statutory mandate of the litigation mediation should be checked with when deception and falsity is apparent or established. My lord, where is the deception and falsity apparent or established here, my lord? Is the plaintiff, my lord, approach the court with some deception or falsity or apparent misrepresentation? Look, by suppressing the date of knowledge. The proposition that the commercial court have a role, albeit a limited one, should be accepted. So a very limited role. Otherwise, it would be up for the plaintiff alone to decide or resort to the procedure under 12A of the Commercial Court Act. An absolute and unfettered right approach is not justified if pre-suit institution mediation under 12A of the Commercial Courts Act is mandatory as held in the case of Patil. Miller kindly takes the next one. It's no longer res intriga that Section 12A is imperative and any suit filed without exhausting the remedy under 12A is liable to be rejected. Now, Miller, in the Patil, those were money suit and there were no application for interim reliefs. Paragraph 63 onwards, Miller, it says so. The only exception to the requirement under 12A is a plaint contemplates grant of urgent relief. This requires urgency to the pleaded and must be supported by necessary facts and documentary evidence. Undoubtedly, this is very narrow window which has been left open in Jamini Monor, in which case the plaintiff seeks artificially, falsely or deceptively create an urgency only to circumvent with the requirement of pre-suit mediation or settlement. There can be no straitjacket formula in such case. Each case depends upon its facts, can only appear from the plaint and the documents in support. It is also true that the length of time does not disentitle the plaintiff to seek dispensation. Well, if this is the finding, where is the case of Miller rejection? If the learned judge himself is saying it is true that the length of time per se does not disentitle the plaintiff to seek dispensation. So where is, Miller, the case of rejecting my claim without coming to the case of falsity of deception or, Miller, perpetrating fraud on court at the time of, Miller, obtaining dispensation under 12A? The totality of the circumstances has to be considered from the holistic reading and must be given to the plaintiff. However, urgency has to be primarily ascertained on the basis of averments in the plaintiff supported thereof, protractive shipping, etc., etc. Well, this is the defendant's case. In the facts of the case, the plaintiff has admitted that they had knowledge of the impugned product since January 2024. Well, I cannot escape that, Miller. Having admitted this factual position, it was incumbent upon the plaintiff to provide ground to justify as to why he waited for 9 months before instituting the suit and obtaining dispensation under 12A of the Act. Millard, is it a case, Millard? Lordships, Millard, with deepest of respect to the Honorable Single Judge Millard, he has sent length of time doesn't matter. But Millard, justification is what? I am already before us quasi judicial body for rectification. So if I'm already fighting with you in one forum, where is the question of mediation? Secondly, it's a recurring cause of action and the products are absolutely similar, as said by Millard the Jamini Monohar. So this was shown, Millard, to the court in question, and Lordship can see the products in question, those are absolutely similar. Nevertheless, Millard, may I just continue? The plaintiff is wholly silent on this aspect. The omnibus averment, that being the suit is pertaining to intellectual property right, the cause of action is continuous and recurring, hence the need for urgent relief. Millard, this is what the authorities, Millard, cited before the learned judge says so, Millard. There is no quarrel with the proposition. The cause of action in a suit for infringement passing off is a recurring in nature. If that be so, it's a finding again, Millard, in my favor. How the suit can be dismissed, he is saying so. Nevertheless, for a purpose of granting dispensation of 12A of the Act, any examination can only be conducted that touch to the right to sue arose. Millard, this is, Millard, contrary to the settled principle of law of, Millard, Bengal waterproof, that the right to sue arose for, Millard, a cause of action which is static, and for a cause of action which is, Millard, not static but a recurring one. Otherwise, this is, Millard, reading down or, Millard, expanding the scope of, Millard, Jamini Monohar. Jamini Monohar, Millard, never said so, Millard. Otherwise, no suit for you would ever require pre-institution, mediation or settlement. Millard, if there's a case, Millard, someone wants to obtain license or, Millard, there is falsity, deception, apparent, the defendant shows that you suppressed and got an order. Then, Millard, obviously, Millard, paragraph 10, Millard, will come into operation. The section cannot be interpreted in a manner to remain the same meaningless or nugatory. Millard, I don't think, Millard, this judgment was cited by Millard, my learned friend, Millard. I don't think so, Millard. Jamini Monohar, the Supreme Court held that the suit's urgency was artificially created, would not bypass the requirement of 12A. Non-furnishing of explanation or justification depends upon the knowledge of the alleged infringement of passing off in a clear attempt to artificially create an urgency. In absence of any pleading to justify delay, Millard, this is, Millard, reading down, Millard, reading into Jamini Monohar. There is no question of relying on in supporting evidence at all. Unfortunately, the plaintiff is merely a cut-paste job. The plaintiff has not even attempted to proffer explanation as to what transpired to the date of knowledge till the filing of the court. The next is, Millard, what the attempt to slip in submissions or additional authorities in the notes. Lordship will kindly check with the notes as filed in court and with the learned judge has recorded it was cited. Whether there is an attempt on my part or anyone, Millard, appearing to slip in, Millard, additional judgments, Millard. In the notes, which were not cited during the hearing, is unfair, improper, perilous, to say the least. So the pleading which has been deceptively inserted in the notes of argument, this showed could release the matter and same before a coordinate bench which has granted dispensation of 12A. This was not my submission. The submission is, Millard, there are two division bench. One is saying go to mediation in case of IP matter also, which I had argued and I lost. If there is enormous delay, that's, Millard, SRMB. There are other division bench is saying, Millard, please do not non-suit the plaintiffs, relying on Jamini Monohar. So, Millard, as a counsel, Millard, I told, Millard, the Honorable Single Judge, this is the case. And the Honorable Single Judge on this identical fact shows gave me the leave. Where is the change circumstances today revoking the dispensation in question? Significantly, point was never argued at the time of hearing, nor any additional citation referred to. The decision of Srishti Development Corporation is distinguishable. This was not a case of not being pleading to justify. All the authorities cited by defendant are inapposite. Judgments cited for the precedents are binding in this context. They are rendered in Quinn versus Latham. This is also quoted Millard. Millard, in view of the above, GA number 6 of 20 stands allowed. There shall be orders in terms of prayer A and B of the master summon. IP com number 28 of 2021 is dismissed. All interim orders stands vacated. Millard, the interim order was till 28th. The order 28th of April, Millard. It was mentioned, Millard. The Honorable Single Judge says nothing doing. You have slipped in the judgment. So, Millard, I will not extend the interim order. So, it stood, is Millard, lapsed, Millard, on 20th. Now, Millard, if your Lordship now takes, Millard, two things, Millard. If your Lordship, Millard, takes, Millard, the order of 1st of October 2024. C1 তো নাই তো ঠিকঠাক বলছো কেন আছে 5 Lordship will take page ভলিউমটা বলো ভলিউম Millard, kindly 319 টা কোন ভলিউম একটু বার করে দিন সেকেন্ড বল yes third one has Lordship found out?
This is the order granting you dispensation? No.
The order which is granting me injunction, Millard. Kindly look, Millard, whether I had made any falsity or deception. Kindly have a look at the internal kindly have a look at the internal page of 3 of the order, Millard. Internal page 3 of that order in question. 319 টা বার করো না এই পাতাটা কত হচ্ছে 321 Lordship will take, Millard, the Millard second last paragraph. I just want to point out, in the month of January 2024, from detailed search in the register of trademarks, the plaintiff came to know that the defendant has obtained registration of the mark Polypankaj in class 17. When the plaintiff came to know, the plaintiff initiated rectification against the defendant, praying for removal of the mark of the defendant, and the same is pending adjudication. Counsel for the plaintiff submits the defendant's mark are deceptively similar to the plaintiff marks. He submits defendant also using the get-up and trade dress used by the defendant and is affixed to delivery pipes and sold. At the time of hearing, the plaintiff has also produced the products as well as the defendants, wherein the court finds the defendant has adopted a deceptively similar mark, Polypankaj, for the purpose of selling the pipes along with a deceptively similar color scheme for his or in the products, the plaintiff has mentioned Mazbute ka wada umid se zyada, and the defendant has shown umid se zyada mazbute ke wada, just opposite words used by the plaintiff. The counsels of the plaintiff submit defendant has obtained registration of the mark Polypankaj, but has reduced the size of the mark Poly and increased the size of the mark Pankaj in the label. He submits the use of the impugned mark, which is identical to the plaintiff's trademark in respect of similar device, to passing off as that of the plaintiff. Having heard the plaintiff is running, the plaintiff is running the business since 1976 under the mark Pankaj Flex and Pankaj. The defendant has obtained registration in the year in 2003 as Polypankaj, but the defendant has adopted deceptively similar trademark Polypankaj for the purpose of selling its hose pipes and other pipes. Deceptively similar color scheme as of the plaintiff. The plaintiff has also produced in and Millard, ultimately injunction was granted. So, Millard, the date in question, 24th January 2024, finds Millard place in the ex parte order, also finds place, Millard, in the impugned order, at the time of rejection, at the time of grant of the order. So it's not a case of Millard falsity or I Millard try to hoodwink the court Millard at the time of moving the ex parte order in question. Now, if your lordship now takes page number ভলিউমটা দাও না 855 টা পেজ কত হবে 855 তো দেখুন তোমরা না একটা হার্ড কপি রাখবে মামলা করার সময়
হয়তো হিন্দিতে 855
will I kindly have a look at 886
886
the order in question is 6th of May Millard. Millard, by an order of 21st of April 2025 the parties were directed to file Millard written notes on submissions. So Millard, prior Millard to hearing taking place Millard, the plaintiff at least Millard came forward with the written notes on submissions, which lordship will find at page 887. Lordship will find 21st of April 2025, page 886. In the meantime, both the parties are directed to file their written notes on arguments. That is, Millard, prior to the hearing commenced. Now, preliminary note, which we always file at page 887. If your lordship takes Millard, just Millard for the purpose of Millard satisfying my conscience also. Page 890, if your lordship takes page 890, running part of my written notes, my argument, Millard Jamini Monohar. Lordship has seen Millard Jamini Monohar 890.
Yes.
Now Millard Veda Seeds and Kohinoor.
Yes.
Lordship will find Millard continuation. It's also there. Then Kohinoor Veda Division Bench is also there. Then Shrishti.
Yes.
Then Millard I just place the next paragraph. Millard, after Shrishti, I just place it, Millard. These were all part of the unique. So naturally today, Millard, if I'm arguing before your lordship, if I'm citing Jamini Monohar from the impugned order, and I'm not citing it separately, can it be said, Millard, that I have slipped in judgments? I may cite from a judgment, a portion of a judgment. That's permissible. Lordships allows it for the time. ঠিক আছে আমি বলে দিচ্ছি যেটা হয়েছে বলে তো আমি তো আগের দিন বলে ওগুলো আমি বলবো না Millard, kindly take Millard just after Millard Shrishti. I just place my written notes so I don't place the judgments again. Because nowadays I also try to be as concise as possible, Millard. The Honorable Court, this Honorable Court in Unique versus Really Agritech, reported in such and such that held that whether there exists for need of urgent relief or not is to be examined in the totality of the circumstances. There should be a holistic approach. The fact that there is merely a time gap, knowledge of infringement of rights or breach of obligation institution of the suit is only parameter which determines whether the suit contemplates urgent relief or not. So I cited Unique. Now the learned judge himself records the defendant cites Millard Kemco. That is also part of my note. It should be plaintiff. It is settled position that a time lapse between the knowledge and date of institution of the suit would not be a factor for disentitlement of urgent reliefs in the case of Kemco Plast. a time lapse of 8 years did not prevent the plaintiff from obtaining relief of the Honorable Court or dispense with the rigors of 12A of the Commercial Court Act. In the case of quality service solution, a time lapse of 14 years did not prevent the plaintiff from obtaining urgent relief, and the Honorable Court dispensed with the rigors of 12A of the Act. In the case of Dr. Reddy, the time lapse about 1 year did not prevent him from obtaining urgent reliefs with the rigors of 12A of the Act. The urgent reliefs and the Honorable Court dispensed with the rigors of such and such. Ultramedia, a time lapse of 2 years did not prevent from obtaining urgent reliefs, and considering the arguments of the instant case, there's a time lapse of 8 months, which itself can time lapse of 8 months, which cannot be a ground for revocation or dispensation of the rigors of Section 12A of the Commercial Courts Act. Now, Lordship will kindly take me, Lord. These are the judgments in question. I have given the reference. These are part of unique also.
Have you supplied copies also?
To your Lordship, I have the copies.
You will give us, no?
Obviously. His Lordship is asking something, Milord. With this, Milord, observation as against me, Milord, I am carrying at least 4 copies. Yes, sometime, Milord, this is my problem, Milord. If it's a part of a judgment, Milord, I try to, Milord, read it from there, Milord. It saves time. It saves the annoyance of the judge also. In any event, there is no delay in approaching the court, as relief claimed in the subject suits are for passing of Bengal waterproof has been quoted. Now, Milord, this coordinate bench, this is part of my note, which the learned judge has got a little upset, because the coordinate bench's order I have shown. That date is, Milord, there reflected in the order. The coordinate bench, this is not my sentence, Milord. This is a sentence of the division bench. I'll show, Milord, the coordinate, Milord, may I just place, in any event, after Milord, just Milord, continuation, last portion 892. In any event, there is no delay in approaching this honorable court, as relief claimed in the subject suits for passing of an infringement, and the plaintiff has specifically pleaded there is a cause of action, continuous cause of action to approach the court, as the act of passing off committed is a fresh cause of action to approach the court, and Bengal waterproof is cited. The paragraphs in the plaint are not cut copy paste. These are from Bengal waterproof and a judgment of the division bench in Prapti fashions. And one other judgment is there, Milord, which I had the occasion to argue when my Lord Justice with Chattopadhyay, Milord Raichottopadhyay, my Lord Justice Banerjee was sitting with my Lord Justice Oshim Banerjee, Hindustan Liver, recurring cause of action.
Doesn't look good, does it? Sleeping with mouth open
doesn't look
in a high court.
Doesn't. Now, Milord, kindly take. This is not my language that I had tried to, Milord, avoid the court since the court was against me. Milord, in a given matter, Milord, some matters court will be for me, with me, the court will be against me. Where is the question of, Milord, avoiding a so-called interlocutory court dealt with an IP matter, because my bread and butter comes from there. What is the question of avoiding? I'll be, Milord, rendered jobless if I try to avoid that judge, Milord. Honorable Judge, Milord, taking up the matters. Not that I, Milord, because many matters are there, Milord. So where is the question of avoidance? Not that one of matter I, Milord, go and argue. The coordinate bench of this court has considered the facts and circumstances, documents, and exercised the discretion, and allowed the plaintiff to file the suit without resorting to pre-litigation mediation. And this honorable court, sitting singly, may be pleased not to interfere with the exercise at the present and the later stage. Otherwise, the proceedings will be dilatory. This is the exact quotation from Srishti Infrastructure. If you have got an order, if there is no change circumstances, please do not reject. You can vacate an interim order on ground of suppression. Now, Milord, this, Milord, when I went to cite, Milord, Sri Lala Bhagavan Chand and Mary Pushpam, Milord, the Honorable Judge said, please, this was already part of my note, because my note was already, Milord, prepared. I was arguing on the basis of system with the Honorable Single Judge follows. You come with a written notes, argue. When I went to cite, Milord, that if a division bench has made a finding, as a single judge, 2 findings, it has to be referred. This is the judgment of the Supreme Court. When I went to cite that, Milord, the Honorable Single Judge says, please leave it something with for me to decide. Naturally, my lord. If he doesn't want, it's embarrassment, my lord. Lordship can ignore this. But the law, my lord, it stands, my lord. If there are two division bench, what the single bench is going to do? It's nothing to be so upset, my lord. Now, my lord, kindly have a look at the judgments in the question of, my lord, the first of our court. Paragraphs of the plaint I am not stating. My lord, kindly take, my lord, the judgment of this court in question. Srishti. Copy the. Copy the extra copy the. Ache. Copy so the show copy. Millard, Gabriel, there is one more authority. I'm not citing it because it doesn't take into consideration.
But this
Jamini.
is what creates the problem. If he is citing a judgment, he should either hand it over or not mention one Gabriel, one something else.
I haven't.
This is what creates the problem.
I haven't said.
If he is citing something, he should like make over a copy.
I have given my learned friend a copy, Millard. I have given my learned friend. Lordship has the notes, Millard.
Yes.
Millard, just Millard, what was the case there? This appeal raises very interesting questions. These questions are now in many appeals where the interpretation and application of 12A of the Commercial Codes Act are involved. To appreciate the facts need to be said. Now, Millard, Order 7, Rule 11, now Para 3. By a detailed examination of the plaint, the learned judge went into question whether an interim relief was contemplated in the suit. She ruled that no such relief could be said to be contemplated. This was a money suit. By a judgment and order dated 24th May 2024, the plaint was rejected. The other application for interim reliefs, injunction and rejection of plaint were also rejected. As redundant, the suit was also disposed of, hence this present appeal. Now, kindly have a look at Para 9. The intention of the section is plain. If in a suit no urgent relief is contemplated, an effort should be made towards resolution of the disputes between the parties by mediation before institution of the suit. So contemplation, not Millard. If the suit cries for Millard and interim relief, it's a contemplation of the plaintiff in question. Like money suit, this situation may arise. Ultimate decree is a money decree, but you contemplate urgent relief by way of Order 38 Rule 5, because the defendant will dispose of the property. Obviously, if mediation failed, the suit could be instituted. If it was successful, there would be nothing to file before the court. Section 12(1) provides that the type of the suit can be instituted without pre-litigation mediation. The first and perhaps foremost objection taken is the maintainability of the appeal. Now, Millard, kindly take Millard paragraph 10. It was argued on their behalf that leave under 12A was required before institution of the suit, since in this court 12A leave to institute without having undergone pre-litigation mediation was refused. The suit was deemed not to have been instituted and not in file of, therefore the suit could not be dismissed by rejection of the plaint. Now, Millard, kindly take Millard. In Partil Automation, Para 11 versus Rakeja Engineering Limited, Supreme Court has specifically conceptualized two situations. First one, on presentation of the plaint, consideration by the court whether the suit contemplated urgent relief before institution. At this stage, without reference to the defendant, the court has an option of rejecting the plaint under Order 7, Rule 11 of the Code of Civil Procedure. The second one was discovery by the defendant after institution of the suit, after issuance of summons, that 12A leave was required and was not taken on filing of the plaint. He had the right to take out an application in the section under Order 7, Rule 11 of the Code of Civil Procedure for rejection of the claim. If the court found that the suit does not contemplate any urgent relief, but nevertheless it has been instituted with a proper undergoing pre-litigation mediation, it could reject the plaint under the provision. Now, my lord, decree, what is decree is stated, my lord, then the appellability, lordship will kindly omits that. Kindly, my lord, now takes paragraph, my lord, 17 or my lord, paragraph 18. The ratio of the, that's my lord, internal page 4. The ratio of Supreme Court in Patil Automation Private Limited versus Rakeja Engineering Limited reported in such and such is that 12A is not merely procedural law but substantive law, hence mandatory. A suit where urgent relief is not contemplated and filed without undergoing pre-litigation mediation is barred under Order 7, Rule 11D of the Code of Civil Procedure. So, my lord, no dispute with that proposition. There are certain suits, my lord, which ultimate relief is a money decree or some other decree which partition ultimately is going to come. Under Section 12A, a cooling period is provided for the parties to explore mediation. Where a suit is dismissed under Order 7, Rule 11, a fresh suit can be filed, but the court fees is payable over and again. When under 12A, the plaintiff is compelled to go for mediation, there is a ray of hope that the matter may get settled. It is a win-win for all sides if mediation is successful. Now, my lord, kindly have a look at para 20. In paragraph 92 of the judgment, the court proceeded to analyze the point at which it could be said that the suit has been instituted under Order 4, Rule 13 of the court. The claim is due to be instituted when it complies with the requirements under Order 6, Order 6 and 7. Now, kindly takes paragraph 21. In paragraph 98, the court says there is no institution of the suit unless the courts admits the plaint and register it in the suit register. Presentation of the plaint may not amount to institution of the suit for the purpose of Order 4, Rule 1 and Section 12A of the Act. Before registration of the plaint, suit can be thrown out on the ground that the 12A requirement has not been complied with. So this is not that stage. At the threshold, my lord, it was not a case that the plaint was thrown out. The SRMB judgment which the Honorable single judge relied upon, it was a case of rejection of the plaint or not entertaining. I don't say, my lord, rejection, not entertaining the plaint at the threshold without taking recourse to pre-suit mediation. Now, my lord, kindly, what Patil Automation did not decide. The facts enumerated were not before the court and consequently not the case. That paragraph, a case where the defendant has no intention for resolving a dispute by mediation, in fact, is fiercely opposed any claim by the plaintiff. When leave is sought to file a plaint without pre-litigation mediation, such leave is granted. He immediately makes an application for revocation of the leave on the ground that the plaintiff ought to have but did not undergo pre-litigation mediation. No urgent relief is contemplated in the suit. The court has to decide the issue. This takes some time. In this period, the defendant is assured that the suit remains suspended and no order can be passed against it. Even if the court decides that urgent relief was contemplated and the relief was rightly granted, the defendant may challenge such order by revision, although an appeal may not be provided against such order. If a defendant, while challenging the institution of the suit with 12A, comes up with a proposal for mediation, it could be said that he is approaching the court for revocation of leave for quicker and effective resolution of the dispute between them and the plaintiff without undergoing long expensive decision. This was not the case here, Miller. There was no offer, Miller, annexed to the Miller application itself. But without any proposal for mediation, objection to the plaintiff obtaining 12A leave or making an application to revoke, it should be viewed with suspicion by the court. This is a finding. So you can ask for revocation after leave has been granted on the ground, limited specified ground, but there should be accompanying a specified proposal. In what way you want to take? You want to take license in this type of matter? Want to restrict your territory? Want to change your get-up, etc., etc. Now let us look at some decision. Paragraph 29. With regard to the meaning which is to be ascribed to the phrase, if the suit contemplates urgent relief, a decision of this court in Gabriel versus Maria Fabrication remark. The legislature, in my opinion, has used the expression contemplated to express the intention that any interim relief may be required at the time of filing of the suit or may be required at the time of the defendant expressing the intention to do some act to defeat a decree to be passed. So the test, in my opinion, is not whether an urgent interim relief is immediately required, but whether the averments in the plaint point out to the situation that even before expiry of 3 months, the plaintiff may have to need of to joint urgent relief. Now, Millard, Jamini Monohar is quoted, Millard. I am not, Millard, reading it again, Millard, because I have placed from the impugned order itself, Millard. Now, Millard, kindly have a look at the next page where the impugned order does not, Millard, record paragraph 8 of Jamini Monohar. That's internal page 7. Clearly, the Supreme Court, this emphasis is given, this here, the emphasis is ours. Clearly, the Supreme Court establishes the standard which the plaint and the application for urgent relief have to be tested amongst other on the following grounds. 1. The commercial court has to examine the nature, subject matter, cause of action, and the relief sought. Millard, if I stop here, pause here for a moment, and I, Millard, say, Millard, that, Millard, if a commercial court has to examine the relief in respect of a IP matter, or an invocation of bank guarantee, or an immediate disposition, Millard, whether it should waive, Millard, that, Millard, requirement of 12. Millard, examine the nature, subject matter, cause of action, and the relief sought. Next, the facts and circumstances of the case to be considered holistically from the viewpoint of the plaintiff. The plain documents and the facts should indicate that their need for urgent relief. So, Millard, I pause here for a moment. Millard, I had moved it. Millard, not that it's a case, Millard. Today, Millard, the plaint, Millard, proceeds entirely on the deception and suppression or gross suppression. It's not a case. The date remains January 2024. Where is the question of reversing and turning back the clock? Not that I had come, Millard. Like, Millard, in one of the matter, Lordship says, Kisan Mela, Lordship remembers 2018.
Yes, yes.
Kisan Mela. 2018, the plaintiff says knowledge just now, May 2024. This is such a case, Millard.
Metravi. No.
Yes. No, that's, Millard, unique.
No, Kisan Mela?
Kisan Mela is unique. There are 3 of the matters.
Oh, yeah.
So, Millard, Kisan Mela, and Millard, the directors are communicating, Millard, or the dealers are communicating. This is suppressed. So, Millard, this is a case, unique case, falling with the limited window. Is it such a case with a limited window? Because if it's a case of Order 7, Rule 11, you have to proceed on the basis of my plaint. Take my contents of my plaint as true and correct. That is a recurring cause of action and I need an urgency. Can you now say I don't need urgency? Can you dissect the principle of Order 7? Because what you are pressing into operation is without an Order 7 Rule 11. With a limited window in 12A, without falsity and deception. Otherwise, that also couldn't have been looked into. Because I come to court with a cause of action. It has to be, Millard, sacrosanct, Millard, gospel's truth in Order 7, Rule 11. Yes, it may be, interim order may be refused. But here, Millard, it's a worse scenario. Ex parte states, interim, Honorable Single Judge says, Millard, yes, this is urgency, I give you relief on basis of your cause of action. On that, Millard, January 2024, can the suit now be dismissed on the ground of delay? You should have refused the order. That's a higher right I have got. That is exactly Supreme Court is saying, merely because interim order has been refused. It is not a case, Millard, your order, your Millard 12 dispensation will also be revoked. Because those are on 2 different. Interim order is on the higher pedestal, Millard. The 3 links have to be, Millard, satisfied. Millard, may I, Millard, just continue, Millard, with this? Now, Millard, therefore, to dismiss a plaint, a commercial court has to undertake a thorough examination of the case while also looking out at the deception and falsity. The plaint cannot be dismissed at the threshold for failure to prima facie establish urgency. So if that be so of the division bench, my lord, on the ground of delay, my lord, could my plaint have been, my lord, rejected? Say, my lord, paragraph 31, the plaint discloses a simple money suit, but it is likely on notice of it, the defendant might start disposing of some of the assets to defeat the decree that might have been passed against him. So the plaintiff may contemplate urgent relief of an attachment before judgment, but did not plead it in the plaint as a cause of action has arisen at the time of institution of the suit. Miller, if this was weighing, Miller, I put it in the question form, Miller, to myself. If this was weighing on the court that some things should be there on the plaint. Now, Miller, it's a question, Miller, whether you treat intellectual property matter as a recurring cause of action, or you frame, Miller, because this frame, Miller, it's not a recurring cause of action. Right first accrues. This is there in the Limitation Act, Miller. Lordship knows, Miller, right first accrues in respect of one's rights is threatened, Miller. Article 59. In earlier 1908, Miller, it was a right accrue. So there is a departure. So learned judge has somehow, Miller, got it there, and Miller, this has been, Miller, pressed into operation here, Miller. Now, Miller, kindly look at the next one, paragraph 32. Please note the wording of the section 12A. The legislature does not mention plaint. It uses the word sue. It implies that the word contemplation. Hence, it avoids such as averments or statements made in the plaint. So, if I contemplate, look, the goods are identical, the marks are identical, is deceptively similar. I am the prior user at least by 50 years. Well, it is my contemplation which the court accepts, not my averments which the court is accepting. I have already gone to the register for challenging your mark. I am before a legislative, I am before a quasi-judicial body, challenging your registration. What mediation I will do? That is exactly Kemco plus Miller Helps which I will place. Hence, it avoids the words averments in the plaints. In the other words, the legislature does not say from the statements or averments in the plaint, urgent reliefs obtained should be apparent. So, Millard, again, Millard, this finding, in other words, the legislature does not say from the statements or averments in the plaint, urgent reliefs obtainable by the plaintiff should be apparent. I would interpret this section as suggesting a fact at the time of presentation of the plaint before the judge from the averment in the plaint, an affidavit to be filed by the plaintiff would appear that contemplation of the plaintiff in a situation for urgent relief might arise in a period when mediation has to be undergone. The court may allow the plaintiff to institute the suit without mediation.
Will you continue after recess?
Millard, can it be, Millard, on Wednesday? There's Mr. Rai Chaudhary knows. Problem I am facing, Millard, is the emergency in the house. Millard. My sister-in-law.
Oh, I see. Something personal? No. If you give the excuse of another case, no. Personal, yes, of course.
Personal. He knows it. I may have to go, Millard, in this very serious.
Likho. Mr. Ghosh, learned senior counsel representing the appellant, opens his submission but does not conclude. Paragraph as requested by Mr. Ghosh, let this matter be listed again on
Wednesday, Millard. I'll be there.
কিন্তু 18 তো আগে হবে না কি হবে আগে নন কমার্শিয়াল তারপরে anyway
I'll be there. I'll conclude. I have to cite the Supreme Court.
June 18 as the first matter under the heading appeals from decree.
2 p.m. Lordship will be taking non-commercial today. 2 p.m. non-commercial.
Today?
Yes.
No, we'll continue. Yeah, so commercial we have exhausted. So then non-commercial from 2 p.m.
Only on 18th, Millard, post 3:30, Millard, I'll be having some. Very well.
চলো এই দাঁড়াও ঘুমিয়ে পড়েছে
Grateful.
commercial, item number 327.
This is the matter your lordship was hearing, my lord, the reciprocal obligations under a consent award.
Yes.
We had filed an application saying that the Jodhpur property should be deleted from the execution, and that was allowed. Now, the only question, my lord, your lordship heard Mr. Dhiren Sharma, thereafter Mr. Surojit Nath Mitra was arguing.
Yes.
Only question which is whether, my lord, the compromise decree imposes reciprocal obligation. If it does not, then, my lord, the individual clauses of the decree can be executed wherever the property is situated.
Yes. Now, today, what is to be done? They are not here.
Well, let us wait. I think
Passover.
Passover, my lord, because, my lord, it's quite an old award. Lord, at least, my lord, my client is terminally ill, my lord, is requested.
All right, Passover.
Item number 8.
Chalo.
Item number 9. Passover. 9 and 10. 9 and 10. Passover. Item number 11. Passover. Item number 12. Item number 13 and 14.
12.
Pursuant to your lordship direction, I served the notice, but from the track report, I find that he has shifted to some other place. And my client had filed a criminal case against him before the Ranchi court. In that, he is facing the non-bail warrant for last 2 years. He is absconding. He has left the Ranchi place. Now we have the information that he is staying somewhere in Bangalore. So I need to serve the copy because I don't want to do the ex parte. No purpose.
How long? Tell us. 2 weeks.
For 1 month, kindly try.
Very well.
Your lordship may give me direction to serve a notice upon the advocate who appear before the trial court.
He may say that he is no more authorized.
That's right.
Learned advocate for the appellant
Right.
says that from the track report, it appears that the respondent has moved from his last known address where service was effected, service of notice was effected. Stop. He says that so far as the appellant has been able to ascertain, the respondent is somewhere in Bangalore presently. Stop. On his request, we adjourn this matter for a month to enable the appellant to serve notice on the respondent. Paragraph lists the matter once again on aaj koto tarikh? 16. Yeah, July 14.
He is a software engineer and plaintiff is a joint commissioner of income tax. His entire family has been destroyed. He has made such an allegation against him, against the adultery, about adultery. So entire family is ruined. That's why he want to proceed with this.
Very well. Come back. 14 July.
Well, deeply obliged.
Item number 13 and 14.
Passover.
Item number 15. Item number 16. Item number 17. Item number 18.
I appear for the respondent award holder.
Item number 19. Item number 20. Item number 21. 22.
I have to bring for the respondents. It's a suit for infringement of trademark, my lord. The single bench confirmed the interim order from which they had preferred an appeal. This matter was reserved for judgment. Thereafter, the Honorable Judge was transferred as the Honorable Chief Justice of Odisha High Court. As a result, my lord, this is again.
This has to be heard afresh.
Yes, my lord.
Now, what do you call this? Number 22.
Yes, my lord. Ghazi Murshidul Arifun versus Salt Lake Society.
Trademark.
Yes, my lord, trademark. This is IIHM is the trademark, my lord. And my lord, the appellants herein.
They are not here. Passover. Passover.
Item number 23. 24.
Pass over.
25.
Well, 24 is also, my lord, it's an appeal arising out of a suit for infringement of trademark, where, my lord, the Honorable Single Judge has been pleased to dismiss an application seeking extension of time to file written statement. After that order was passed, the suit has been transferred to Commercial Division. The defendants have filed an application under, my lord, Section 15, subsection 4 of the Commercial Codes Act, which is pending.
You're for the respondent?
I'm for the plaintiff respondent.
Pass over.
Item number 25.
Lord, this is my appeal, my lord.
Pass over.
Item 26.
Pass over.
Item 27.
Pass over.
Item 28.
Your Lordship, I am appearing on behalf of the appellant in item 28. I am seeking a Lordship leave to appear online because I have a twisted ankle. Lordship, there on the last occasion I took adjournment on the ground of talks of settlement which has been going on. We need another 4 weeks time to finalize the terms, Your Lordship. I am the appellant. 28, Your Lordship.
Learned advocate for the appellant says that talks of settlement are still in progress. Talks of settlement are still in progress. Stop on his request. Let this matter stand adjourned for 4 weeks and be stand adjourned 4 weeks. Stand adjourned and be listed again on July 14.
Lordship, deeply obliged.
Item 29. Item 30. Item 31. Item 32. Item 33.
Item 30. I'm for the appellant, Your Lordship. The other side, they're not present, Lordship. I'm requesting for an adjournment on this matter. Item number 30.
Item number 34.
34.
Item number 35 and 36. 37. 38. 39. 40.
I'm for the respondent, ma'am.
41. 42. 43.
I'm opposing the appeal.
44. 45. 46. Second call. Item number, possible matter, item number 8. 3 to 7.
I am appearing for the respondent, my lord. The award is of 2013.
You understand everything, but it's rather strange that
Unusual. I was just
unusual.
telling my junior, my lord, why there are so many of them.
Yes, they are the appellant.
They are the appellant, my lord.
Following our usual formula in the second call, we'll dismiss it.
But again, my lord, I'll only pray, my lord, do not follow the usual formula that they will restore by mentioning, my lord. Because, my lord, this is the matter.
How can I do that? How can I only adopt 50% of the procedure? No, otherwise, unless...
Can I say this, my lord? Kindly keep it as a specially fixed on next original site day whenever your lordship takes.
We can't fix the time. It will retain its position. It's at the top.
Then your lordship will record that they are not
Yes, yes. And what? And dismiss.
No, as a last, ki korbe? Very well, if they take the chance, if they come, your lordship will restore.
Usual order kore dao. Dismiss for default.
But in case it is restored, it should retain its.
Yes, yes. বুঝেছো কৌশিক? যদি রেস্টোর করে দিই যে পজিশনটা যেন ঠিক থাকে।
Obliged. আমরা আছি একটু লিখে
You give your appearance, Mr. Dashgupta.
I know. Item number 8.
Should I appear for the respondent number 1?
Dismissed. Usual.
Item number 9.
Give your appearance, Mr. Gupta.
Item number 9 and 10.
Appear for the respondent. 9 is mine. 10 is my appeal. 9 is Mr. Chaudhary's appeal.
Mr.
Sabyasachi Chaudhary was appearing, my lord, in this matter.
So what is to be done? We can hear your appeal. Judges, what should we do?
I'll briefly indicate what are the facts, my lord. Then my lord will decide.
Yes.
But I was made a defendant in a suit. I filed an application was taken out seeking injunction of enforcement of a negative covenant against me, my lord. I appeared, filed a reply on merit as well as, my lord, and maintainability, saying that the dispute was commercial in nature, my lord. Learned Court below heard the parties on affidavit, my lord, and held it's a commercial dispute, rejected the plea, but also proceeded to deal all the facts on merits, my lord, and pass judgment on thereon. Now, some issues which the court has decided, my lord, despite holding it's a commercial dispute,
Gone against
have
you.
gone against me. Therefore, my cross appeal, my lord. But the real my lord, person agreed with Mr.
Having
Chaudhary.
held that it is a commercial
Yes,
suit.
could not have been, in my respectful submission, could not have entered any further in the issue, my lord. But this is what has happened, my lord. Therefore, I'm aggrieved by that portion of the order, my lord, where my points which were raised were considered and rejected, my lord, despite holding that the court has no jurisdiction.
Well, since there are cross appeals, we'll just say not today.
I shall inform Mr. Chaudhary.
Yes.
Item number 11.
11, usual order, thank you.
30.
What is that? কি হচ্ছে? আরে কিছু সুন্দর বাজান, এটা খুব খারাপ, এটা শুনতে লাগছে। ওইখান থেকে আচ্ছা। Yes, give your appearance. 11 appearance টা নিয়ে নাও।
13, 14, 13, 14.
13, who is appearing? 13 to
Is the
yes.
Mr. Krishnaraj Thakkar was to give the reply, my lord.
Yes. He is reading you.
He's leading me.
You are here, Mr. Gupta.
I can start, but
No, what do you mean you can start? You can start and conclude. You want time?
yes, or otherwise.
Don't start and do half of it and say now I want adjournment. If you start, complete. Otherwise, and no relay.
Then I don't have an option, but I'll pray for a not today.
Not
My
today.
Lord, I am objecting to this adjournment because tomorrow execution case is coming up. I have served them the stay application in appeal. My Lord,
But may I indicate one thing?
Then, Mr. Gupta, you tell us that you will obtain time tomorrow in the execution.
I indicate two things before.
all sorts of submission that
I'll indicate.
Question of indicating you are seeking accommodation. It is only fair that tomorrow at least don't proceed.
I understand. But
Yes.
the only thing is, there was a stay application filed in the appeal that was disposed of on the ground that they will not secure. So it was
there was
disposed
no stay
of.
application.
So now they're filing another stay application.
Oh, it was
Now
disposed
it
of.
is secured.
Yes. That's my only submission.
My Lord, may it also be listed.
File it, it will be listed. Nobody can stop you from
Your
filing.
Lordship will give me leave to file short service.
Sir, give them a copy.
I have
We'll
served-
consider on merits.
I have served them.
Whether it's maintainable or not, we'll consider that.
It has been fully secured, whatever is their claim in execution.
Not secured. What they have done is they have indicated that in their bank account, they have kept that money, but that's not a savings bank account. That's a current account. They say they have kept the money.
It is kept apart.
But in my humble submission, my lord, they should deposit that with the registrar original side subject to the outcome of the appeal. Otherwise, this is not a security. So, my lord, if that order your lordship passes, my lord, we will not proceed with the execution, not do anything.
Your Lordship will
Anyway, today you are seeking time, so tomorrow don't do anything. That's all I'm saying. We'll take it up tomorrow or day after, whenever it comes.
Then my Lord,
Yes.
pray for one day.
Simply not today. Simply not
My
today.
application can be listed tomorrow along with the appeal.
File it. It will be listed. File it.
I will need special leave from your Lordship
কি
because
কি বলছেন দিয়ে দাও তাহলে লিভ হ্যাঁ তো যা করার করে দাও লিস্টে এনে দাও কাম ব্যাক টুমরো
Let it remain in the list, but will not do anything.
yes
Item 9 and 10, my lord. We were just hoping there's an order, my lord.
oh you are hoping there will be an order let there be an order 9 and 10 এ করো you are Ramjilal no
No, my lord. Sorry, my lord.
Acha. The appellant in APOT 99 of 2025 is not represented. Stop. Learned counsel appears for the appellant in APOT 95 of 2025. Ageta 99 chilo. Stop. Paragraph. We have briefly heard learned advocate for the appellant in APOT 95 oblique 2025. Stop. To give another opportunity to the appellant in APOT 99 of 2025, let this matter stand adjourned. Let these matters stand adjourned and be listed again Wednesday. Fairly long order. You may be entitled to double fees also.
Keep your list.
Item number 15.
My lord, before my lord takes up item number 15, I'm sorry to, my lord, come in between, my lord. Item number 8 was dismissed for default, my lord.
Yes.
My lord, I'm extremely sorry, my lord. I was on my way here. I heard the list was called twice, my lord. And my other side
Restored.
is, may I? My
At
other side
Corona.
is here, my lord. Kindly takes it up tomorrow or any other day.
Not today.
I'm extremely grateful to my lord.
Which one, Mr. Banerjee?
15. No, my lord, I also had 327, which has been dismissed. I wasn't there. But, my lord,
Restored. Yes. Corona 327. আমার সব আনন্দগুলো নিয়ে নিচ্ছে।
Same position, my lord. That was. Let it be retained in the.
You don't want to do it today?
Very.
No, he doesn't want to. We will only say not today.
Only say. Then, my lord, it will retain its.
It will. It will.
Yeah, 15.
I remember the days of Justice Shujit Siddha.
Yes, my lord. But there's orders, my lord, one in the morning, one in the afternoon, again another one in the evening.
But that was substantive order.
Yes. Injunction made, then so how can my lord pass an order without here? Very well vacated.
All right, not today.
Fifteen.
15.
Item number 15.
My lord, I am for the appellant. My lord, dear my lord, was pleased to, my lord, condone some delay, my lord, was pleased to condone the delay, and then my lord was directed us to pay costs, which we have done, my lord. This is the affidavit of compliance. My lord, this is, my lord, from a.
How much cost?
My lord, 10,000, my lord.
Only?
Yes, my lord,
No matter you are appearing only 10,000.
that is what I also submitted.
This is not fair, my lord. But we were not aware of the order. That was the difficulty.
Yes, Kaguz.
My lord, this is an order passed, my lord, really ex parte, transferring, my lord, the winding up petition to, my lord, the NCLT. There is no, my lord, application which was made. It was a sumo to transfer in that sense.
Ex parte, then why didn't you approach the learned single judge, Mr. Banerjee? Order 9, Rule 13 is there.
My lord,
Normally, this is what we do.
But, my lord, order on the face of it, my lord, will show, my lord, why, my lord, it is.
This point we were hearing in a group bunch of matters.
Yes.
In a bunch of matters, you are appearing also.
I'm also appearing.
Mr. Joint Tumitru was.
Yes, correct. The Joint Tumitru, my lord, is for, my lord, the appellant. I'm for the.
So we'll admit the appeal and let us hear it with that. No.
My lord, though, my lord, here, I'll tell you, these are of both family companies. There's an arbitration, my lord, which is pending with regard to, my lord, these companies. There are also, my lord, orders passed by the arbitrator with regard to maintaining status quo. Now, this winding up petition, my lord, was filed, my lord, in 2015. And from time to time, my lord, it was adjourned on the ground, my lord, of settlement. Those orders are there. All of a sudden, my lord, it came up, my lord, on, my lord, 6 January 2023, and my lord got transferred to the NCLT.
So which is the company against which winding up petition has been filed?
My lord, that's, my lord,
Parth. Surya is the petitioner.
Yes. And my lord will find, my lord, the orders which were, my lord, passed. Kindly come to, my lord, page 33. If Malad wants, we can also Malad have it heard along with that other matter. If that's
Yes, this is what I was thinking. The same point is involved there also. Whether without an application,
yes,
it can be
that's
done.
the Edelweiss.
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 Jessup matter.
Jessup.
I'm appearing for Malad Edelweiss. That's right.
Bharat Wagon or some.
Yes.
Hey, Kaushik, এটা কি appellate side? Those were original side?
Original.
হ্যাঁ, naturally.
Because it's from winding up.
বুঝতে পারছো কোনগুলো একটা? হ্যাঁ, অনেকগুলো একসাথে আছে। Okay, লেখো। This appeal is directed against an order dated January 6, 2023, whereby a learned judge of this court has transferred CP 111 of 2015, along with all connected applications, to the National Company Law Tribunal, Kolkata. Stop. Paragraph. The appellant. Who are you, the appellant? You are a contributory.
No, Malad, I am the company.
Oh, you're the company. He will have
Because there's no winding up. This Malad, it's a transfer.
Transferred.
The learned judge of this court has transferred CP 111 of 2015 along with all connected applications to the National Company Law Tribunal.
Stop. The winding up petition was presented against the appellant company.
Yes.
Paragraph. The appellant says that in the absence of any application for transfer, the learned judge ought not to have and could not have transferred the proceedings to the NCLT. We again a bracketed National Company Law Tribunal bracketed NCLT likhe diyo.
That's one of the
NCLT
first round.
To NCLT. Stop. Ache, tomorrow. Very good.
Oh, very good. Well, that's the first round. The second round is also Malad, there are special circumstances under which Malad should not have been transferred.
Additionally, and in any event, because of the special circumstances of this case, the order of transfer should not have been made. Paragraph. The first point urged by the appellant is also in issue in a bunch of matters which have been fixed tomorrow, kalke date da bracket at 12:30 p.m. Stop. Let this matter be listed along with those matters kalke on such and such.
Grateful.
হবে না, কোনো একটা হবে না। শোনো,
Grateful.
Oh, Mr. Banerjee,
Yes,
those Jessup matters have been marked hard in part as a special case on the request of all appearing counsel.
Oh.
Therefore,
So it may not happen tomorrow, Malad.
tomorrow it will be listed but will not be taken up.
Very. Whenever Malad it comes up, I don't
Yes,
think
yes,
we should,
yes. No, we will in all probability assemble that bench on Friday.
Friday.
In all probability, because some matters have been assigned. No, if you are not there, we'll keep it on some other day. You provided security personnel. No.
No.
That was Mr. Suraj.
But I'm the financial
Financial.
creditor. Malad. I'm Edelweiss, Malad, financial creditor. I'm the only financial creditor.
Security personnel.
I have all the security.
Security personnel, Mr. Surajit Nath.
Yes.
No security personnel. The entire security is mine, Malad.
Very well. লাগিয়ে দাও এগুলোর সঙ্গে, কালকে তো হবে না হিয়ারিং।
Your Lordship, take up the next time. May I seek an indulgence?
Which one?
Item number 15.
Well,
Yes, Second. Item 13 and 14, I'm sorry, my lord, I couldn't make it. The Lordship has been pleased to make it, not today, my lord. The two appeals, now that mean profit appeals. I'm in some difficulty tomorrow, my lord, maybe the next day.
you want to do it today?
I can do it today, please, my lord.
Where's your other side?
Other side is, they left probably, I think. They were
Then when do you want it?
day after tomorrow, please.
Wednesday.
Wednesday. I'm so grateful. Deeply obliged.
Which one?
13, 14.
Grateful.
Matter 3 to 7. Lordship is keeping in next day, my lord.
Said not today.
Adjournment is being granted on their request, my lord, that line. We are under some sort of a line.
3 to 7 টা ওটা বোধহয় একসঙ্গেই হচ্ছে অর্ডার দেখো তো
Yes, my lord, it's common.
হ্যাঁ ওটা লেখো on the request made by learned advocate for the appellants comma let this matter stand urgent for the day and be listed again কালকের ডেট দাও retaining their positions সেই জন্যই matters বললাম let these matters
Item number 16.
16, my lord, it's that matter, my lord, which my lord was hearing. It's at
yes.
Yes, Srirampur suit and my lord High Court suit dismissed on the ground of my lord Order 2, Rule 2, as well as my lord one line saying my lord it's a commercial suit. My lord, I was showing my lord, I've shown the two plaints where my lord the Srirampur suit, my lord, this relates to my lord land which we had purchased from Hindustan Motors. Srirampur suit, my lord, is in respect of certain obligations which the Hindustan Motors were to do.
Municipality.
Yes. The High Court suit, my lord, is a municipality. The other one is State of West Bengal. There were certain obligations which, my lord, the respondent, or rather, my lord, the defendant, first defendant had to discharge to the state, which they did not do.
Is Section 10 also involved here? No.
No, my lord, Section 10, if at all, my lord, it could have been only Section 10. But, my lord, here, Order 2, Rule 2, my lord, has been used, my lord, to dismiss my Calcutta suit. My lord, kindly well, the Srirampur suit is 2021. Page 114. No, ঠিক আছে
আমাদের কাছেই করে ওই রিওপেনিং ডে
যেন বলে দেয় page 114. I'm sorry. Volume 1. Paper 2. Paper 2.
That's the Srirampur suit.
Yes. Well, I had already had a look at it. Just to see, just page 114. You will find Bengal Shriram High Tech City Private Limited. That was the plaintiff. Then versus Hindustan Motors Limited and State of West Bengal. The release I had shown at page 169, 170 rather. Decree directing the defendant number 1 to pay the dues of the defendant number 2 দিয়েছে
নেক্সট ভলিউমটা হ্যাঁ তুমি তো গপ্প করছিলে
169 নাকি 117 160 I'm sorry, my lord.
Yes.
Readingটা কোথায় গভর্নমেন্ট অর্ডারে দেখাচ্ছে reading 6 Yes. Well, a decree directing the defendant number 1 to pay the dues of the defendant number 2 state government under GO of 13 September 2006, save the sum of rupees 7 crore 90 payable by the plaintiff as 4% non-compete fee in respect lands. Then decree directing attachment and sale of the remaining lands of the defendant 1 at Uttopara more fully described, identified and scheduled hereto, and whatever right or interest defendant 1 may have over in respect of the same, and for the appropriation of the proceeds of such sale to be made and adjusted against the dues of the defendant 1 to defendant number 2. That's one of the state. Then decree directing defendant 1 to indemnify and to keep the plaintiff safe and harmless, indemnified in respect of all claims and demands on it by the state government. Declaration of plaintiff's obligation under the assignment agreement is confined to making payment of 4% of the sale proceeds of the developed area of the project land developed during revived term of 5 years from the commencement of construction or till date the defendant 1 does not compete, not at page 173, with the plaintiff, whichever is earlier. Then decree directing the defendants to accept the sum of rupees 7 crore 92 after adjusting sum of rupees 5 crores already paid, stroke tendered by the plaintiff to the defendant number 2, state government for on behalf of the defendant 1 in full and final settlement of all claims. Then F, decree of perpetual and restraining defendant number 2. This is very important because 2 also we have asked for relief. State government from revoking, suspending or withholding any permission, approval, clearance, no objection granted to the plaintiff or required by the plaintiff for the continued development of the project land on ground of any default. Then 175. Defendant 1 to make payment under the GO dated 13 September 2006. So prayer D is directly against the defendant number 2, the state, because the other suit will find municipality is the party, and there we have there was a demand which was made by the municipality for some dues of the land, which we have paid for mutation. We have paid.
Recover that.
Recover. So that is a totally separate cause of action and not really part of this. Because will recall a question had fallen from court saying that whether I could have combined, whether I could have made this claim also against the defendant number 2 in the previous suit, the Calcutta suit, which High Court suit which we have done, whether this claim could have been also made against defendant. To that, my answer was, enabling provision will not mean a dismissal. Then, I'll come under joinder of cause of action, whether I could or could not have. But if it doesn't arise from the same, if it's not the same cause of action, not even arise, if it's not the same cause of action, then there's no bar under order to rule 2.
Liberty is not a mandate.
Yes, absolutely. That's perhaps that's the best way to. I'm grateful. That's the. An enabling provision will not mean. Absolutely not. I couldn't have said it better. Liberty is not a mandate. Absolutely. So that's really the point on that, and also show a Supreme Court decision. The last really that's on in 2025. Luckily on this order to rule 2 itself. This is Pardiwala's judgment on the issue. Then 175, decree of mandatory injunction directing defendant number 1 to continue to perform its obligation under the agreement with the plaintiff to necessary to enable the plaintiff complete its construction of project land. H, decree of perpetual injunction restricting defendant number 1 from acting in breach of any of its obligation under the agreements with the plaintiff, which may in any manner impede or hinder with the plaintiff in completing its construction at the project land. These are my prayers, and just one paragraph can have a look at page 118, 117, paragraph 6. And my lord turns over the page and sees my lord either 118 or 119. 119 my lord is typed. This is my lord setting out of my lord that government order. Because the government order my lord gave them leave for my lord development. HM Defender 1 is granted freehold rights to develop or cost to develop entire part of 314 acres of land under schedule by way of development of integrated IT township.
100?
My lord, 119, 119. It just starts, my lord, that paragraph starts at 117. My lord, it's a little confusing because my lord, typed copy, my lord.
Yes.
It quotes, my lord, that government order.
Yes.
We are not on merits. I'm just showing, my lord, the frame of the suit is something totally different. So then, my lord, after that, my lord, 120, 120, paragraph 7. Pursuant to the leave granted to it by the GO of 13 September 2006, Defendant 1 decided to sell the plaintiff's land upon identifying one Shriram Properties Private Limited, presently known as Shriram Properties. The Defendant 1 approached Shriram Properties Private Limited to develop the plaintiff's land project through a special license. So, this is really the frame of the suit. And the High Court suit, my lord, will find the plaint, my lord, will find the 41. My lord, the plaint, my lord, will find at page 3. Bengal Shriram High-Tech versus Hindustan Motors Limited, and my lord 4 is chairman Uttar Para Kotrang Municipality. Reliefs are, my lord, at page 17. It's only, my lord, it's a money decree as against, my lord, defendant number 1. And we also plead that, my lord, in paragraph 16, saying plaintiff further states there are other disputes between plaintiff defendant 1 and there are other proceedings pending. However, the cause of action for the present suit is completely distinct from such other proceedings. Para 32, my lord, at the top of page 16. And then, my lord, page 41, my lord, is the demand, denial. Yes. Page 41, my lord, is Hindustan Motors letter this is, my lord, their denial. That's some merits. My lord, this is, my lord, their denial which, my lord, prompted us, my lord, to file, my lord, the suit. Now, my lord, kindly take, my lord, this judgment. So this is 2025 SCC online SC, page 82. लिखे तो ना पूरा लिख लो ना पैराग्राफ पूरा उल्टा रिपोर्ट हाँ सर 35 to the kindly come to para 35 right? 35. এখানে মার্ক করেছি নোট অলসো paragraph 35 analysis. Order to rule 2 CPC reads as under suit to include the whole claim. Then order to rule 2 is not set out. Then general principle, the underlying order to rule 2, the object of both the rules 1 and 2 of order 2 is to prevent the multiplicity of suits. Order to rule 2 is founded on the principle that a person should not be vexed twice for one and the same cause. It is a rule which is directed against two evils, that is splitting up of claims and the splitting up of remedies. What order to rule 2 requires is that the inclusion of the whole claim arising in respect of one and the same cause of action in one suit. However, this must not be misunderstood to mean that every suit, every suit shall include every claim or every cause of action which the plaintiff may have against the defendants. This is the mandate and the liberty, my lord, I think. Therefore, where the cause of action is different in the two suits, order to rule 2 would have no application. On a more careful perusal of the provision 37, it can be seen that order to rule 2(1) reads as every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, whereas the word used in rule or order to rule 2(3) are the same cause of action. Despite being so, the words the cause of action used in order to rule 2(1) must be read to mean the particular cause of action. Only on such a reading one can arrive at the inference that where there are different causes of action, order to rule 2 will not apply. And where the cause of action are the same, the bar imposed by order to rule 2 may apply. Then, my lord, 38, order to rule 2(1) requires every suit to include the whole of the claim to which the plaintiff is entitled to in respect of a particular cause of action. However, the plaintiff has an option to relinquish any part of his claim for the purpose of bringing the suit within the jurisdiction of any court. Order to rule 2 contemplates situation where a plaintiff omits to sue or intentionally relinquishes any portion of the claim which he is entitled to make. If the plaintiff so acts, then he shall not afterwards sue for the part or portion of claim that has been omitted or relinquished. Must be noticed that order to rule 2 does not contemplate the omission or relinquishment of any portion of the plaintiff's claim with the leave of the court so as to entitle him to come back later to seek what has been omitted or relinquished. Such leave of the court is contemplated by order to rule 2(3) in situation where a plaintiff being entitled to more than one relief on a particular cause of action omits to sue for all such reliefs. In such a situation, the plaintiff is precluded from bringing a subsequent suit to claim the reliefs earlier omitted, except in a situation where leave of the court had been obtained. It is therefore clear from a conjoint reading of the two provisions of order to rules 2(2) and 2(3) CPC that the aforesaid two sub-rules of order to rule 2 contemplates two different situations, namely where a plaintiff omits or relinquishes a part of a claim which he is entitled to make, and secondly where the plaintiff omits or relinquishes one out of the several reliefs that he could have claimed in the suit. It is only in the latter situation where the plaintiff can file a subsequent suit seeking the relief omitted in the earlier suit, provided at the time of omission to claim the particular relief he had obtained the leave of the court in the first suit. In words and phrases, meaning attributed to the phrase cause of action in common parlance was stated to be the existence of those facts which gave a party the right to judicial interference on this behalf. Then, my lord, the phrase cause of action, my lord, is considered. Then kindly come to 41, where Muhammad Khalil Khan, my lord, that Privy Council, my lord, is discussed. My lord, the test with regard to the Privy Council and Muhammad Khalil Khan, my lord, paragraph 41. Supra also discussed the principle governing the applicability of order to rule 2 CPC and the several tests thereof in detail. On a thorough examination of the reasoning given in several decisions, opined that the correct test is whether the claim in the new suit is in fact founded upon a cause of action distinct from that which was the foundation of the former suit. Where the question is whether the cause of action in two suits is the same or not, one of the tests that is applied is whether the same evidence would support the claims in both suits. Well, that is absolutely not the case here in our case. If the evidence required to support the claim is different, then the cause of action are also different. The cause of action of two suits may be considered to be the same if they are identical in substance, not merely technically identical. Therefore, the application of the rule depends not upon any technical consideration of the identity of the forms of action, but rather upon a matter of substance. court in Muhammad Khalil Khan acknowledged that what would constitute the cause of action suit must always depend on the particular facts of each case, and true difficulty in each instance arises only upon the application of this rule. Relevant observation reproduced herein below. Then, my lord, we can come to paragraph 73. My lord, in paragraph. Are you sure this is correct? 73. My lord, 43. Sorry. My lord, paragraph 43. Summary of the principle laid on Muhammad Khalil Khan are as under, then principle laid on cases thus far discussed may be thus summarized. Then, my lord, it really, my lord, it's just summary. It's actually summarizes 40. Then, my lord, kindly come to 47. Yes, on a conspectus of the aforesaid discussion, what follows is that the object of order 2 rule 2 is to prevent the multiplicity of suits, and the provision is found on the principle that a person shall not be vexed twice. Mandate of order 2 rule 2 is the inclusion of the whole claim arising in respect of one of the and the same cause of action. One suit must not be misunderstood to mean that all the different cause of action arising. This is important. It must not be misunderstood to mean that all the different cause of action arising from the same transaction must be included in a single suit. Several definitions have been given to phrase cause of action and can safely be said to mean every fact which would be necessary for the plaintiff to prove if traversed in order to support his right to judgment of the court. Such a cause of action has no reason whatsoever to the defendant that may be set up by the whatsoever to the defense that may be set up by the defendant. Nor does it depend upon the character or the relief which is prayed for by the plaintiff, but refers to media upon which the plaintiff asks the court to arrive at a conclusion in his favor. Then similarly, several tests have been laid out to determine the applicability to order 2 rule 2 to a suit. While it is acknowledged that the same heavily depends on the particular facts and circumstances in each case, it can be said that a correct and reliable test is to determine whether the claim in the new suit is in fact founded upon a cause of action distinct from that which was the foundation of the former suit. Additionally, if the evidence required to support the claims is different, then the cause of action can also be considered to be different. Furthermore, it is necessary for the cause of action 2 suits to be identical in substance and not merely technically identical, which was also said before. Defendant takes shelter under the bar imposed by order 2 rule 2(3) must establish that the second suit was in respect of the same cause of action as that on which the previous suit was based. B, in respect of that cause of action, plaintiff was entitled to more than one relief. And C, being thus entitled to more than one relief, the plaintiff, without any leave obtained from the court, omitted to sue for the relief for which the second suit had been filed. The defendant must also produce an earlier plaint in evidence in order to establish an identical cause of action between both the suits. There was a deliberate relinquishment, larger relief on the part of the plaintiff.
So essentially, Mr. Banerjee, where causes of action are different, this leave business doesn't apply.
Correct. Same cause of action to
several reliefs.
Then yes, like my lord, what we usually do, we cannot ascertain the damages which we have suffered at present. Therefore, my lord, we are asking for leave. So it has to be relatable to that particular cause of action. And my lord, just kindly look at.
So what would you say your causes of action are in the two suits?
My lord, the first cause of action is me, defendant number 1 and defendant number 2, respect of my lord, the government order and certain obligations which were my lord, to be discharged between my lord, 3 of us really, particularly my lord, defendant number 1.
And the second one, you having discharged the obligation of Hindustan Motors, you want to recover that amount.
It's a decree, my lord, which and the evidence would also, my lord, be totally different. In the Calcutta suit, my lord, High Court suit, I just have to go and show factually that I paid and legally that I'm entitled to. Whereas the Sriampur suit, my lord, is a law, is a really, my lord, a different fact and different cause of action, my lord, which, my lord, is against relating to, my lord, again, different number 2, the state. Because there, my lord, it was a question, my lord, of me developing, my lord, that integrated township. And certain obligations had to be discharged by Hindustan Motors as well, including payment of money. Out of, my lord, the sale consideration. Now, my lord, in this, just, my lord, one more paragraph, 73, I think, my lord, just. Right. 73. My lord, 73. And just before that, my lord, 72, my lord, can you see the heading? Entitlement to, along with the availability of the relief is requisite in determining the applicable order to Rule 2. And then, my lord, 73, and then kindly come to 86. It is established law. Sorry, my lord. It is established law that the principles governing the applicability of provisions of Order to Rule 2 do not operate as a bar when the subsequent suit is based on a cause of action different from that on which the first suit was based. And that the identity of the cause of action in both the suits must be the material consideration before the court which decide the applicability of this provision to a second suit by the plaintiff. It would be incorrect for us to hold that merely because the pleadings in plaint filed in OS number 28 of 2008 and plaint filed in OS number 122 of 2000 similar to some extent, the cause of action are also identical. Rejecting the plaint in the second suit, that is OS 122 of 2008, would result in depriving the respondent one from claiming the relief of specific performance of the agreement for sale dated 24 January 2007 and the cancellation of the sale deed dated 24 January 2008. In this regard, we have examined the entire factual matrix along with the cause of action in which both the suits were founded. Through a holistic reading of the plaints placed before us, in our opinion, reliefs in the subsequent suit are in fact founded on a cause of action which is distinct from that which is the foundation of the former suit. Facts which are necessary to be proved and the evidence to support the claim in the second suit are also different from that of the first suit. Therefore, it cannot be said that the respondent number one would have prayed for the reliefs claimed in subsequent suit at an earlier stage. This one we found,
Srirampur suit was filed in the year?
2021.
21.
And this, the High Court suit.
When did you make payment to the municipality?
Before.
Before.
2018. But my submission is, that cause of action may be existing at that time. I may not have included.
Correct.
Because order to Rule 2, that's why this judgment perhaps helps us. I mean, it is really supports our case to say that unless it is the same cause of action and the same evidence, your really order to Rule 2 doesn't come in. And in this, looks at now the impugned order.
এই মেমোটা আছে?
Commercial to the Peru for I know two things. I'm sorry, before I come to the impugned judgment, I'm so sorry. I'm just, if just looks at the application which they had made at page 57. I'm so sorry, page 57. Huh? 57.
Yes.
Lord sees 58 Lord is the affidavit support of master summons. Paragraph 2 mentions this suit. Paragraph 4 mentions the previous suit. Reliefs are set out. Then Lord, page 61. Then 60. Sorry, paragraph 5, 61. It would be evident from the meaningful reading of the plain before the learned Srirampur Court that the cause of action pleaded in said title suit number 162/2021 instant civil are one and the same. That is the sale of 314 acres of land in Uttarpada. I'm sorry, Mala, that is not
the cause
correct.
of action.
It might be one of the foundational facts, but that doesn't mean make the cause of action the same. By the respondent 1 to the plaintiff grant, reliefs claim both the suits arise out of same cause of action. Not correct. Then Mala, kindly look at paragraph 7, page 62. See, paragraph 7, I find Malad section 10 pleading is there, also directly and substantially in issue. Then Malad, paragraph 9, it is imperative that the trial in the present suit be stayed. Then 10, no prejudice would be caused. And then Malad, 11, they say it will be dismissed. And on this ground, Malad, page 54, Malad, is the master summons. First pair is dismissed, alternatively should be stayed. And very important, Malad, here, no point is taken, Malad, that it's a commercial suit. Now, Malad, now, Malad, kindly come to the impugned order, Malad, in the memorandum of appeal. Malad is looking at memorandum of appeal. One, present suit is filed by the plaintiff. The last 3 lines of paragraph 1, filed by the plaintiff is the nature of commercial dispute. Plaintiff has not obtained leave under section 12 of the Commercial Codes Act. Malad, this is now nowhere in the application. And I'll show Malad why the learned judge Malad thinks Malad this is a commercial suit. Then Malad, paragraph 2, paragraphs are set out. Of the Srirampur suit, Malad, right up to paragraph page 14. First, Malad, paragraph page 12. Then paragraph 3, Malad, are the prayers set out. Then, Malad, page 14, paragraph 4 is set out. Sorry, paragraph 4 sets out, Malad, the present suit. Page 17, paragraph 5, reliefs are set out. Then, Malad, page 18. Both the suits filed by the plaintiff are connected with the same property. Again, Malad, not same documents, and defendant 1 is the same. In the previous suit, plaintiff has made the state of West Bengal service to the Secretary, Department of Land and Land Reforms, defendant number 2. But in the present suit, the defendant number 2 is the chairman, Uttarpada Kotrang Municipal. Both the suits, plaintiff has sought reliefs against the defendant 1 only. This is not, Malad, correct, Malad. The reliefs are set out. Plaintiff has filed the first suit on 16th August. Present suit is filed by 26th May. As per the specific case of the plaintiff in the present suit, that despite receipt of the letter dated 7 September 2018, defendant 1 has not paid his share of dues of the property tax due, to which the plaintiff's land being an area of 102.84 acres were neither being separated nor mutated in the name of the plaintiff. Finding no other alternative, the plaintiff has paid an amount of 1,74 being the share of property tax due, which is required to be paid by the defendant 1 and 2. 8. In the present case, plaintiff has paid for recovery of an amount of rupees 1,74 along with interest against the defendant 1. This cause of action for filing the present suit is already existing. This cause of action, now very important, this cause of action for filing of the present suit was already existing when the plaintiff has filed the previous suit before the learned court of civil judge senior division Srirampur. This is not irrelevant because this cause of action, whether it exists or doesn't exist, is not the issue really. I may not, if it's a different cause of action, I don't get hit by order to rule 2 at all. Then my lord, page 19. Courts in the Srirampur court, in the Srirampur suit, my lord, I had asked for order to rule 2, which was not given. It was not taken finally, my lord. It again, my lord, won't make a difference. Then previous suit plaintiff was also paid fully under order 2. Sansaj 17 has passed the following order. So order to rule 2 is not there. Then my lord, paragraph 10, page 20. Order to rule 2 set out. Then 11, 12, my lord, cases are set out. Then my lord, page 22, paragraph 13. In the present suit, also when the plaintiff has filed the previous suit, cause of action of the present suit was existing or was existed. The previous suit was filed on Sansaj, present suit filed Sansaj, paragraph 19 of the present suit, cause of action arose on 7 September, and thus no fresh arose to file the present suit. As regards to whether so this is my lord, end of my lord, order to rule 2. This is all. And as regards to whether the suit filed by the plaintiff is commercial in nature, on perusal of the statements made in paragraphs 8, 9, 10, 11 of the previous suit being titled suit number 160 of 2021, and the admission in the present suit being CS number 138 of 2022 at paragraph 30, wherein the plaintiff has admitted that the nature of transaction between the parties is purely commercial and the rate of interest is not only appropriate and proper but also necessary to compensate the unjust benefit enjoyed by the defendant one. Thus, the court finds the suit filed with a commercial nature, not filed as a commercial division. And therefore, in view of the above, subsequent suit filed by the plaintiff Sansaj is as well as suit is commercial nature. I'm sorry, my lord, with great respect, my lord, to the learned judge, my lord. Perhaps, my lord, the learned judge has not, my lord, appreciated what is really order to rule 2. There being 2 cause of action is not, my lord. So, my lord, my submission is, my lord, kindly set aside the order, my lord. They get commercial in nature. Lord, may I have my lord's leave, my lord, just for 2 minutes? Can I ask you just
Lord, I shall show your lordship that the cause of action that has arisen in both the suits is one and the same. My lord, I shall take your lordship through the avowments made in both the plaint to demonstrate, my lord, as per their pleadings, what they are seeking and how the cause of action is arisen. My lord, before that, I'll tell your lordship what has happened in this matter, my lord, the background. Now, my lord, this particular land was sold to the plaintiff by virtue of a sale deed. Now, my lord, the sale deed said that I, the defendant and the respondent before your lordship, had given them certain representations, warranties, undertakings that there are no dues under the GO order of 13 September 2006, my lord, which the state of government of West Bengal had pronounced in my favor, my lord. And second is, my lord, I had also said that there are no rates, taxes, nothing which is due and payable from my side. Now, my lord, in order to say that, I had given, these were the representations, warranties, undertakings that I had given to the plaintiff. Now, my lord, today, the plaintiff has a word in both the suits that I have given these representations, warranties, undertakings. But despite that, they later find out that there are not only dues under the GO of 13 September 2006, but there are also certain rates, municipality taxes, which they had to pay, and which was, according to them, contrary to what we have said. And hence they say that in, my lord, both the suits, we have to indemnify them. My lord, essentially what they are seeking is the indemnity provided by me. Why? Because I have breached my representations, warranties, and undertakings. My lord, this is the sum and substance. Now, my lord, in order to substantiate this, my lord, I should show the pleadings from both the plaint and also the reliefs claimed. My lord, if your lordship kindly takes the plaint before the Srirampur court, my lord, it is at page 115. My lord, I should show your lordship. My lord, if your lordship kindly takes page 120, para 7. My lord, the typed copy is at page 121. Lord, has that? My lord, has that? Yes. My lord, I should read out para 7, my lord. Pursuant to the leave granted to it by the GO of 13 September 2006, the defendant number 1 decided to sell the plaintiff's land. Well, it was my land, which was thereafter sold by the plaintiff, sold to the plaintiff, I'm sorry. Upon identifying one Shriram Properties Private Limited, the defendant number one approached Shriram Properties Private Limited to develop the plaintiff's land stroke project land through a special purpose vehicle to be incorporated for the purpose in which the initial shareholders would be the defendant number one and the said Shriram Properties Private Limited. Upon the said Shriram Properties Private Limited agreeing to such proposal, it was agreed that the plaintiff's land stroke project land would be transferred by the defendant number one to the SPV, absolutely free from all encumbrances with clear marketable title at agreed value, to enable the defendant number one to fulfill its commitments made to the state government under the GO of 13 September 2006, and to enable the SPV to thereafter develop the plaintiff's land stroke project land without any letter or restriction whatsoever. Hence, my lord, I wanted to show this paragraph because if your lordship sees the GO, my lord, the GO said you sell the land and thereafter I have to pay certain money to the state government. Those are on the merits. But as far as the sale deed is concerned, it already says that nothing is due and payable under the GO. My sale deed with him. And today, if your lordship sees the declaratory relief that they are seeking is essentially that the state of West Bengal cannot recover any dues vis-a-vis the GO in this Srirampur suit. Now, my lord, if your lordship kindly takes, my lord, the next paragraph that I shall show, my lord. Page 122, para 11. Now, there's a reference of the sale deed and also the undertaking that I've given to them that I should comply with the GO order. My lord, page 122, para 11. My lord, the typed copy is at page 123, para 11. My lord, I shall place this. In view of the financial obligations undertaken by the defendant number one under the GO dated 13 September 2006, and in order to ensure that the development of the plaintiff's land stroke project land is progressed peacefully without any hindrance, not in any manner, impeded or affected by whatsoever means, the above stated sale deeds inter alia recorded that the defendant number one would comply with all the terms and conditions of the government order, and undertaking of the defendant number one to such effect was also recorded in the sale deeds. Now, my lord, the next paragraph, para 12. The above sale deeds further recorded that the defendant number one had not violated any commitments made to the state government and contained express covenants so as to effect that it would strictly observe and comply with all the terms and conditions of the GO dated 13 September 2006, including the utilization of the sale proceeds to finance economic revival and rejuvenation of its existing automotive complex in Uttarpara in accordance therewith. In view of its promise to perform all such obligations under the GO dated 13 September 2006 by the sale deeds, the defendant number one also indemnified and to keep the plaintiff saved, harmless, and indemnified against all actions, claims, and demands in this respect. Now, my lord, the next paragraph, my lord, is with regard to representations and undertakings. My lord, that is at page 132, para 21. Lord, typed copy is at 133, para 21. Lord, I shall place it. Having paid the entire sale consideration of 284.47 crores for the project land and having acquired ownership of the same, the plaintiff expected the defendant number one to fulfill its obligations under the GO of 13 September 2006, inter alia, to ensure that the development and construction and marketability thereon of the project land was not in any manner hindered or obstructed. This the plaintiff expected from the defendant number one as A. The defendant number one was also a shareholder in the plaintiff company. B. In view of the representations and undertakings of the defendant number one, both in the said development agreement and in the sale deeds. And third, my lord, C is, as under and in terms of the development agreement, the defendant number one had represented to the plaintiff that the plaintiff shall be in a position to immediately undertake the development and marketing of the plaintiff's land. My lord, that is a separate agreement vis-a-vis the development, but I am essentially on the sale deed and the undertakings, representations, warranties, which according to them have been violated by me. That is what I'm on. Next, my lord, if your lordship kindly takes page 155, para 48. Volume 2, my lord. Typed copy is at page 156. Yes. Lordship has that? Yes. The defendant number one is obliged to indemnify and had in any event agreed to indemnify and undertake to keep the plaintiff saved, harmless, and indemnified for all claims of any nature or any claims of remote in nature, including any dues to the defendant number two. Such indemnity is unqualified and unlimited and covered towards any and all claims and demands arising against the plaintiff which has been undertaken by the defendant number one while keeping the plaintiff saved and harmless. Thereafter, my lord, page 161, if your lordship kindly takes page 161, para 54. The typed copy is at page 162. Lord, the defendant number one is obliged and bound to pay its dues to the state government and is obliged to keep the plaintiff saved, harmless, and indemnified against the consequences of non-payment of the dues payable by it under the GO dated 13 September 2006. The plaintiff is, in the circumstances, entitled to enforce the performance of such obligation of the defendant number one to protect the plaintiff's project from jeopardy and to enable the plaintiff to keep the present and future approvals, permissions, and sanctions intact from the state government. Thereafter, my lord, if your lordship kindly takes page 163, para 57. Lord, as it is evident that the defendant number one is seeking to deal with its remaining lands in Uttarpara without making payment of the dues of the defendant number two, the plaintiff is also entitled to a decree for attachment and sale of the remaining lands for defendant number one at Uttarpara and whatever right the defendant number one may have over the same, which are more fully described and identified in the schedule to the plaint, and for appropriation of the proceeds of such sale proceeds to the defendant number two against the dues of the defendant number one to the defendant number two stroke state government under the GO dated 13 September 2006. Thereafter, my lord, the next paragraph, the obligation of the defendant number one to indemnify and keep the plaintiff saved, harmless, and indemnified in respect of all claims and demands. My lord, this is very important. In respect of all claims and demands on it by the state government is a continued obligation. In such view of the matter, the plaintiff is entitled to seek specific performance of such obligation and promise of the defendant number one particularly, as the plaintiff cannot have and has no obligation to pay the same or any part or portion thereof, and consequently to attachment and sale of the remaining lands of the defendant number one at Uttarpara or whatever right the defendant number one may have over the same. Hence, my lord, they themselves aware that they are invoking the indemnity.
Yes.
Yes. Hence, my lord, these statements made in the plaint in itself shows, my lord, that what they are essentially seeking now is that they are invoking my indemnity in terms of the same sale deed. Hence, my lord, cause of action is one and the same. Why? Initially, they say I've breached my representation's warranties, hence I have to indemnify them. My lord, this is the statement made in both the suits, arising out of the same sale deed.
Yes.
Yes. My Lord, thereafter, my Lord, if your Lordship kindly takes page 167, para 60. My Lord, this is essentially because, my Lord, they have sought for leave under order to rule 2 in this paragraph. And my Lord, I should also show your Lordship that they've applied for order to rule 2 before the Shrilampur court. I shall show that order, my Lord. Now, my Lord, if apart from that, I'll just, my Lord, if your Lordship kindly takes the reliefs, I wanted to point out one particular relief, my Lord. Page 171, prayer C. Now, this is the relief from the Shrilampur plaint. Lordship has that. Lord, decree directing the defendant number 1 to indemnify and to keep the plaintiff saved, harmless, and indemnified in respect of all claims and demands on it by the state government. Lord, this is the prayer. Now, my Lord, I shall show your Lordship the order, my Lord, which records that they filed an application under order to rule 2 before the Shrilampur court. Order at page number. Lord, if your Lordship takes page 183, that is the order. Lord, order dated 17 August 2021. I'm sorry.
Yes.
Yes. Lord, order dated 17 August 2021. This is order number 3, my Lord, at the bottom. Plaintiff has filed a petition under Order 39, Rule 1 and 2 of the CPC supported and affidavit for temporary injunction with ad interim effect upon the defendant for restraining them from the suit property on the ground stated therein. Let the petition be put up when moved. Plaintiff has also filed a petition under Order to Rule 2 of the CPC supported by an affidavit. Now, my Lord, this leave is neither granted nor rejected because what I'm told is that they are yet to move it. But they have filed it, my Lord. That is there. Yes. Now, if your Lordship kindly takes the plaint before the High Court, my Lord. Starts at page 3, my Lord. Volume 1. My Lord, lot of emphasis has been laid on the fact that the parties are different in both the suits. But if your Lordship sees, my Lord, defendant number 2 is Kotrang Municipality, Uttarpada. The relevant, my Lord, it's an instrumentality of the state. My Lord, and not just that, it's a pro forma defendant. No reliefs have been claimed against the municipality before this suit, my Lord, in this suit. Now, my Lord, I shall show your Lordship the avowments made in the plaint. My Lord, page 5, para 3. This is again with regard to the sale of land. That's why, my Lord, I'm relying on this particular paragraph.
Yes.
Out of the aforesaid area of 314 acres, an area of 211.16 acres is situated within the jurisdiction of Kanaipur Gram Panchayat, and the balance area of 102.84 acres is situated within jurisdiction of the defendant number 2. The said area of 102.84 acres falling within the jurisdiction of the defendant number 2 were purchased vide the aforementioned sale deeds, both dated December 8, 2007. Such areas are situated with Mauzas, Kotrang, Bahira, and Makla recorded in Khatiyan numbers such and such and are a part of the holding number 1 of Hind Motor Road, Makla, Hooghly. Then, my Lord, para 4 talks about the township that the plaintiff was supposed to construct. My Lord, the plaintiff is, my Lord, this is the land which they were supposed to develop as the developers, my Lord. Yes. Thereafter, my Lord, if your Lordship straight comes to page 9, para 15. Page 9, para 15.
Yes.
The plaintiff states that, as would appear from the aforesaid sale deeds executed by the defendant number one in favor of the plaintiff, there is a clear representation and assurance made by the defendant number one to the plaintiff that the defendant number one has paid up-to-date revenue and tax of inter alia the said area of 102 acres. The defendant number one has further undertaken and agreed with the plaintiff that all rates, revenues, taxes, assessments, and outgoings in respect of the said portion of land payable to the state of West Bengal and stroke or Kotrang municipality and stroke or panchayat and stroke or any other legal body or authority for the period up to the date of the respective sale deeds, whether assessed and stroke or imposed or levied before or after the dates of respective sale deeds shall be paid by the defendant number one. Hence, my lord, here they not only talk about representations, warranties, undertakings given pertaining to the dues, statutory dues arising out of the same land, but they also, my lord, state any dues which are payable to the state of West Bengal and stroke or the municipality. My lord, why I'm saying this is because, my lord, the appellants say that defendant number two is the state of West Bengal before Shrirampur court. Defendant number two here before your lordship is the Kotrang municipality. They are not one and the same. My lord, they are instrumentalities of the state. And second, my lord, if your lordship sees the pleading, they themselves say dues to be demanded by the state of West Bengal and or the municipality. And in any event, my lord, Kotrang municipality is a pro forma defendant. No release have been claimed in this particular suit. And my lord, the cause of action in this suit has arisen prior to the institution of the suit before the Shrirampur court in 2021. My lord, I shall show one or two more paragraphs, my lord, with this suit, from this suit, my lord. If your lordship kindly takes paragraph 16. No, 15 dekhiye. The plaintiff further states that the defendant number one has also extended indemnity to the plaintiff for any action, claim, or demand raised in connection with such rates and stroke or revenues and stroke or tax and stroke or other outgoings in respect of the areas of land so sold by the defendant number one to the plaintiff. My lord, I have already showed your lordship prayer C in the 2021 suit where they are invoking my indemnity, apart from the other averments made in that plaint. My lord, here again they talk about indemnity. Hence, my lord, the cause of action is essentially arising. Why? Because they are invoking my indemnity. They say I am in breach of the sale deed. Hence, my lord, the cause of action is one and the same, arising out of the same sale deed. And today they are aggrieved. Why? Because they are invoking my indemnity as according to them I've breached my representations, warranties, etc., etc., my lord. Lord, I should show your lordship, my lord, a few more paragraphs. Page 10, para 17, my lord. My lord, this is on representation. Despite having made such representation to the plaintiff and despite having extended its undertaking and also the indemnity to the plaintiff, the defendant number one has wrongfully refused to make payment of dues attributable to and payable by the defendant number one. Thereafter, my lord, if your lordship kindly takes page 14, para 28. Page 14, my lord. Page 14, para 28, my lord.
Yes.
The defendant number one, apart from being bound in law to make payment, was also liable to make and discharge such payment under the agreement with the plaintiff, inter alia, as recorded in the deeds of conveyance. And as such, the defendant number one is liable to reimburse the payments made by the plaintiff to the defendant number two together with interest thereon. Lord, here they themselves say that under the sale deed, I am liable to make those payments. And I have represented is what their case is, that all payments are made, nothing is due and payable. Demands were raised, my lord, they had to make those payments, and hence, my lord, in this suit, they are seeking a reimbursement on the basis of my representation in the same sale deed. Hence, my lord, those are the averments what I wanted to show your lordships from two different planes, my lord, to show that the cause of action is indeed one and the same, my lord, and the judgment that has been relied upon, my lord, that my lord, the Cuddalore Power Gen Corporation that has just been cited, my lord. I am relying on this judgment per se, because in itself says that when the cause of action is one and the same, the defendant ought not to be vexed twice to avoid multiplicity of the proceedings. My lord, I'm exactly on that. And nothing precluded them from making these claims before the first suit.
That is all.
My lord, and with regard to that commercial Courts Act point, my lord, 12 capital A, my lord, I shall show your lordship the pleading made in the plaint itself. Page 15, para 30.
Was it one of the points you argued?
No, my lord, point of law. But I'll tell, we have argued that, yes. But it's not pleaded in our application, but we have orally argued. And my lord, your lordship knows, my lord, that partial automation judgment of the Supreme Court says that lordships can take suo motu cognizance of this point, if not argued by both the parties. But I shall show that judgment. My lord, if your lordship kindly takes para 30, page 15, my lord. This is with regard to the commercial transaction, which they themselves say that it is a commercial transaction. My lord, page 15, para 30. The plaintiff therefore seeks decree for a sum of 2.83 crores against the defendant number 1. The plaintiff is entitled to and claims further interest on and from 1st April 2022 at 18% per annum. Thereafter, it says, the nature of transaction between the parties is purely commercial. Plaintiffs are themselves saying that it's a commercial transaction, and it is, because they are real estate developers. They wanted to develop that property for their commercial usage.
Suppose what should the court do if the court doesn't find merit in the contention regarding Order to Rule 2, but is with you on the point of it being a commercial suit? The learned judge has rejected the plaint.
Yes.
So what should we do? We should uphold that rejection, or we should transfer it to the commercial division?
My lord, if your lordship asks me, my lord, I would say that the plaint be rejected on both points of law, my lord. Order to Rule 2, Sub Rule 3 and 12 capital A.
Supposing we are not with you or with the learned
Yes.
judge on Order to Rule 2.
I'm sorry, my lord. My lord, in that case, my lord, the plaint has to be rejected because the institution of the plaint is bad in itself without leave under 12 capital A. My lord, 12 capital A of the Commercial Courts Act is mandatory, my lord. Your lordship knows. If no leave is being sought, my lord, the institution in itself is bad. My lord, I shall come back with judgments on this point, my lord, on 12 capital A that.
No coming back. Finish it.
Very well, my lord. Partial automation. I wanted to place partial automation, my lord, to show that your lordships can take suo motu cognizance of this point. Para number? আমার কপিটা দিয়ে দিয়েছো নাকি? Para numberটা তো বলবো।
Yes.
Yes.
Oh. Time dite hi. In that case, suppose I did not remember. We have fixed a matter at 3:30. So come back.
Very well.
Mr. Banerjee,
Yes.
Address us on the commercial issue.
Right.
Lekho, Mr. Banerjee, learned senior advocate, representing the appellant, concludes his opening submission. Paragraph, Mr. Bose, learned advocate, representing the respondent number 1, begins his argument but does not conclude. When?
Whenever your lordship deems fit and proper, my lord.
We can list it tomorrow, but tomorrow, number 1 first is the appellate side. We don't have so many matters on the
Let it
appellate
be there
side.
tomorrow.
তারপরে কি এটা তো তার নন কমার্শিয়ালি হবে, তাহলে কালকেই থাক। প্যারাগ্রাফ লিস্ট দ্য ম্যাটার ওয়ান্স अगेन অন, কালকে ডেট দিয়ে দাও। হ্যাঁ, এক সেকেন্ড, লিস্টটা কোথায় গেল? এটা কি মামলা হচ্ছে বলতো? বেঙ্গল শ্রীরাম না?
নিয়ে চলে যাচ্ছে, নিয়ে চলে যাচ্ছে।
রাজশ্রীটা বুধবার হয়েছে, তাহলে এটাকে তুমি as the first matter under the heading for hearing.
Great. Great.
Now you have got the chance to cite more cases.
It looks like I'll be citing it for him in the next matter.
330 is your matter?
Yes.
Yeah, but some of the respondents. But this matter has been heard by your lordship on 2 or 3 occasions.
Oh, different bench. Unfortunately, we'll have to see.
You have the choice, Mr. Bachawat, Mr. Bose. A few matters what we have done, which were substantially heard by the other bench, we have released from this list, and you can get them assigned to that bench. And it is easy for that bench to assemble because Justice Rai is sitting singly.
Oh, I see.
We have discussed that. Any day we can assemble.
I don't really.
Or you can start afresh, whatever you like.
We can have it transferred. Because I believe not the same.
You talk to Mr. Bose and tell us.
But I think the previous bench, my lord sitting with Mr. Justice Rao, my lord, has heard this.
Right.
Right. Has been pleased to hear this matter on at least 2 occasions.
So let's do that. Let's have it before that bench. Lekho. Mr. Mitru is appearing for another respondent.
For the defendant number 1.
I'm for the defendant.
That's the easy brief. He didn't have to say a single word.
Huh? He's the one who spoke. You didn't speak.
Don't you realize he's pinching you deliberately? So you'll have it before the though not marked heard in part, though not marked heard in part within single inverted comma, this matter was substantially heard at least on 2 occasions before another division bench, bracket Amara and Omnaran Rai Sahib's naam diye din. Paragraph in that let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. You just write to the OSD with this order. As soon as assignment is made, we'll constitute the bench.
Another bench presided over, my lord, or it's not required to justice?
Another bench, our names will be given. Both the names will be given. Ja. এবার কি হবে? হ্যাঁ? Yeah.
Non-commercial matter item number 17.
This is my appeal. This is a plaintiff's appeal from an order dismissing an application of the defendants, dismissing an application of the plaintiff taken out under Order 7/11 for rejection of the defendant's counterclaim. And on the last occasion, an order was passed directing the defendants to provide the details of the death of the one of the defendants who had passed away, and also the will. But on the last occasion, if your lordships kindly see the order.
Defendant number 1 has passed away.
Defendant number 1 had passed away. Now, my lord, we have been communicated with the information of his death, and we have been told that he has been left by his son, who is already on record, and his wife has not inherited anything.
Who is appearing for the defendants? Mr. Kaur.
Mr. Kaur, yes.
Mr. Kaur, has your client furnished particulars of the legal heirs of the defendant number 1?
Lord, it's already in the plaint. They have filed the plaint. All the details are there. I'll show it to your lordship.
Now, two things I'll indicate. It has been indicated that he has left behind a will. So, that is why we have asked them a letter that whether the will has been probated, who is the executor. Because if a person passes away leaving behind a will, I have to make the executor a party. So we have asked for the details. What we have got in reply was that his son is already on record and his wife has not inherited the property. So nothing really is required to be taken.
No, wife has not inherited if the will is yet to be probated.
Exactly.
Then how can you say the wife has not
That
inherited?
is what we have been told by the other side. So that is why we have asked for the will, and we have also asked for whether it has been probated or not. So, and we have indicated that if any application is required to be taken, we shall. Otherwise, we may not take out an application.
What do you say, Mr. Kaur?
My lord, if your lordship kindly takes the plaint.
What is the nature of your claim?
The suit is for specific performance and the counter claim is for eviction.
Specific performance of a clause in an earlier lease for a period of 30 years, that 30 years have expired. So the suit is in effect non-est.
No,
It is a suit for enforcing a clause in the lease for renewal for 31 years. 31 years has expired.
Oh, not for sale of property.
No.
Oh.
No.
So the suit, you would say, has become infructuous, so to say.
They have filed a counter claim, and our issue is that counter claim is not maintainable because the rent is 10,000 rupees a month, which is within the threshold limit of the West Bengal Premises Tenancy Act, and that apart, the valuation of the counterclaim is 1,20,000. So this honorable court lacks the pecuniary jurisdiction to entertain the counterclaim. These are the two grounds on which, my lord, we had filed the demurrer application. And from an order rejecting the demurrer application, we have come up before your lordship. But what the defendants are now trying to point out is that because in the plaint, we have arrayed the parties as such, so there is no further requirement. But at that point of time, the defendant number 1 is present. His son is also present.
Has the defendant number 1 left behind a will, Mr. Kaur?
Yes.
Has that been probated?
No.
Not probated, then no problem.
That is the information which we had sought.
Now you have got this.
Very well.
Proceed.
My lord, I'm sorry, my lord. Your lordship. I wanted to show 2 paragraphs of the plaint, which has said who are the owners of the property. This is a 23 and 16.
But if my learned senior friend indicates that the will has not been probated, so this is really neither here nor there, then I shall come back without any application. I shall press my appeal. Because this is the issue where it was
Let them proceed with the appeal, my lord.
Yes, we shall.
Let them proceed with the appeal.
Yes.
He says he will, but not today.
Not today because I am led by Mr. Dhruva Ghosh in this matter.
Oh, Mr. Dhruva Ghosh.
So
tell us when.
Whenever, my lord. Next week, my lord, whenever, my lord, your lordships.
Monday. Next Monday. No more adjournment.
Lord, on Wednesday.
Our only ground was?
On Wednesday, my lord. The lordship takes up the matter.
Very well, Wednesday.
Not this Wednesday, but
not this Wednesday. Why?
We have to sit with Mr. Ghosh once before that, and
he's being candid, Mr. Kaur, that he has to sit with Mr. Ghosh.
Because he has never appeared in this appeal. He has been there in the trial court, but since this issue was pending, so my lord.
Very well, dekho. Mr. Kaur, learned senior counsel appearing for the respondents.
Only 610.
Only?
6 Roman 10 had filed the counterclaim.
Oh, respondent number.
He represented.
You're only for 6 Roman 10.
And 2.
Respondent number 2 and 6 bracketed Roman 10.
Yes, will.
Huh? Tells us that the will that has been left behind by the defendant number 1 is yet to be probated. Stop. All his legal heirs are already on record. No. Yes.
Yes, my lord.
Paragraph in that view of the matter, we see no problem in the appeal being heard out. Stop as requested by Mr. Gupta, learned counsel appearing for the appellant, let this matter be listed again on Shombare date the other, retaining its position.
Retaining its position.
On a very short point, my lord, we shouldn't be taking.
I'm grateful to your lordship.
Item number 18.
I appear for the respondent award holder. I appear for the award holder, my lord. First call also, they were not there.
Dismissed. Usual dismissal. আছে তো তোমার কাছে?
Item number 19.
Your Lordship, I'm for the petitioner. I'm being led by Mr. Shobhoshati Chaudhary. He is just the short passover, Your Lordship.
Second call this is.
No, Your Lordship.
Passed over.
Passover.
Passed over.
Item number 20.
Appellant. We will be rising today at about 4:10 because of administrative matters.
I can indicate if your lordship wants, Millard, as to what is the issue.
Mr. Chakraborty?
Or if somebody has
33, 34 and
33, 34. How many respondents are there?
Millard, I am the defendant. There are 37 respondents.
Who's the main answering respondent?
Millard, your lordship's desire was that we should serve all of them, but they.
You haven't?
No, we have. Now they are appearing. In
1 and 2, the main answering respondents?
Yes.
I appear for Venkatesh from
1 and 2,
For respondent number 1 and 2.
you appear. Very good, she's appearing. You're ready with the matter? You're sure you will not disappear?
Not present today.
Who is the counsel?
Mr. Subhashi Singh service.
Where is he?
Engaged in some other court.
That is no ground.
33.
Mr. Datta, you tell us what to do. If you want to proceed, then we'll release your other friends.
But I don't think, Millard.
And not today, only not today. Or what? Tell us, unhesitatingly.
Millard, not. I was actually thinking if it could be taken up next Monday or Tuesday.
Yes, no problem. What are you filing?
Affidavit of services, Millard. Is this bulky, Millard?
Affidavit of service as well as?
It's only the affidavit of service in the two appeals.
কত মোটা? Affidavit of service file in court today.
Both the matters.
একসঙ্গে হচ্ছে না, আলাদা হচ্ছে দেখো।
Millard, I'll tell you, Lordship, Millard, one is, Millard, rejection of my contention that the suit is a suit for land and it's in any event is barred under Order 2, Rule 2. Millard, that was rejected. And the court, Millard, suo motu, Millard, without any prayer, transferred it to a commercial division. Now, Millard, our contention is that it is not a commercial dispute.
Suit is by respondent numbers 1 and 2.
And Millard, there is a subsisting interim order that the suit may not be transferred to the commercial list till such.
Is that limited in time? No.
No, it's still disposal of the.
লেখো আলাদা order করবে। Affidavit of service filed in court today be kept with the records. Stop. Counsel for all the respondents are not present today. Paragraph, Mr. Dutt, learned senior counsel, in his usual fairness, suggests that let this matter be listed again on Monday. I did the other.
I am appearing for respondent number 6 to 33.
Yes.
May I pray for leave to file my wakalatnama in the meantime?
File. Stop. Let that be done. Paragraph, the learned advocate seeking to represent respondent number 6 to 33 will be at liberty to file his wakalatnama in the meantime. Same order in both the matters.
I'll come back.
Item number 22.
But I appeal for the respondent. It's an appeal impugning an order passed in
Mr.
confirmation.
Ghosh, in the first call, nobody appeared.
Yes,
In the
Lord.
first call, nobody appears. So usual order.
Very well.
Give your appearance. Bujicho.
Item number 23.
Yes, ma'am, you are appearing in 23. Nah. Kyun nahi? Same order.
No, well, I appear for the appellant.
Well, I appear for the respondent.
Well, this matter, of course, well, it had been heard on one day for quite substantial period of time by the other bench. It is entirely for your lordship's.
No, it's entirely for you. You tell us, we'll pass a similar order as we did in Mr. Whose matter was it?
Your lordships had spent quite a bit of time.
Then the same order, Oishono, although not marked part, hard in part. Kore dao ota. We would be having our notes also possibly.
Yes.
Give your appearance.
My lord. Item number 24.
Lord, I appear for the appellant in this matter.
I appear for the respondent.
Take a brief to them.
Mr. Chatterjee will keep us engaged for the next 25 minutes.
Yes, madam.
Then we can release your other friends. Bole dao.
All other matters released for the day.
This is an appeal from an order passed by a learned single judge in the non-commercial division, refusing my application for extension of time to file the written statement. Well, this matter has a long and checkered history. The basic point is that this suit was instituted before the enactment of the Commercial Courts Act 2015 in the ordinary original civil jurisdiction. But the subject matter of the suit is a commercial dispute. So after the enactment of the 2015 Act, the suit has been transferred to the commercial division. Now, my lord, my basic point is that at the point of time and on the date, the application for extension of time to file written statement was taken up, the suit stood transferred to the commercial division. But the application was in the non-commercial division and was taken up in the non-commercial division. It appeared in the non-commercial list of the learned single judge. So my basic point is that this is a case of total lack of jurisdiction and quorum non judice, because the jurisdiction had transferred, stood transferred to the commercial division, setting in motion a totally new statutory regime under section 15 subsection 4 of the Commercial Courts Act. Because as your lordship knows, Miller, under section 15 subsection 4, the question of filing of within 120 days, that provision in the CPC will not apply, because that has been dispensed with under the proviso to section 15 subsection 4. And Miller, on a construction of that provision.
Let us see, I'm
yes,
still not very.
Yes, kindly, Miller, take section 15 subsection 4. ঠিক আছে।
A transfer suit, it will not apply.
It will not.
And the commercial court may prescribe a new time period.
Yes, and Millard, the judgments have said that the commercial court has to prescribe at least once a new timeline for filing a written statement. And if the defendant does not honor that, then of course the right to file a written statement is foreclosed. But here in this case, after the transfer to the commercial division, there is no such direction as yet. I'll tell your lordship what happened. This main suit appeared in the court of the learned single judge today in the commercial division. My lord heard the submissions, similar submissions I made before my lord. Without prejudice to the rights and contentions of the parties, my lord wants a mediation on merits. So he has directed that without prejudice to the rights and contentions of the parties may try. It's not really a formal mediation, a settlement process.
It's a money claim. What is it?
No, it's a case. Yes, ultimately money, but it's basically a claim for infringement of trademark. So that has been pushed back to 3rd July. But this question remains and has to be heard, because this is one of the issues which is also crop up before the learned single judge. And learned single judge expressed the view also that in a case where a court has already passed an order rejecting a prayer for extension, whether that principle that I am entitled to a fresh opportunity in the case management process under the Commercial Courts Act still applies, because this is also an order of court which is on record. So, Millard, the appeal remains relevant.
Prima facie, how can a learned judge sitting in the non-commercial division pass any order in respect of a suit which stands transferred to the commercial division?
That is my only limited submission in this appeal. And this, I say, is a question of total lack of jurisdiction. So irrespective of the merits, this order has to go.
You are appearing in the matter.
I'm appearing
for the plaintiff.
For the plaintiff, my lord.
Mr. Ghosh was appearing, Mr.
Yes, my lord.
He has disappeared.
I am led by Mr. Deepnath Ghosh as well as Mr. Shumaba Ghosh, my lord. Was praying for a time, because since both of them are not here, may it be listed any other day.
No, I think the matters were released on that basis anyway.
Yes.
Anyway. I don't stand in the way, but...
Hey, Mr. Ghosh has come.
Mr. Ghosh has come.
So you can proceed.
Yes.
Till 4:07.
Your lordships are rising at 4:10.
4:07. We have some administrative work to do.
Oh, I see.
You have 15 minutes almost.
Yes, yes. Quite a lot of time. Time for about 15 SLPs to be dismissed. না আমার কাছে আছে সেটা কোথায় এটাই দেখছি প্লাস্টিকের ফাইলটা প্লাস্টিকের ফাইলটা কোথায় ওটা তো ও ওইটা না সিঙ্গেল আচ্ছা ঠিক আছে ভেরি গুড এটাই দুই দিয়েছো তো জজ সাহেবকে Millard, for your lordship's understanding and Millard convenience, I have prepared a list of relevant dates. হ্যাঁ সব বলেছি জজ Millard, yes, I have apprised the court about that order.
Without prejudice mediation.
Yes. But the question remains, that's my submission, because this will be ultimately, if the mediation fails, this will be one of the issues in that also. It's not a mediation, it's a settlement process. Yes, I have said that.
Yes, but again, looking at it from the other angle, what if your settlement succeeds?
Millard, if the settlement succeeds, it's a settlement. So all legal points vanish.
Exactly.
That's true. That's true. If the settlement succeeds, then of course.
Then who shall we also adjourn this and await the result of your negotiation or whatever it is?
I have no difficulty.
Otherwise, it may be an exercise in futility. If you can settle the matter, it will be a totally futile exercise.
Millard, I was thinking aloud, Millard. I was thinking like this, that ultimately, this is a commercial matter. Everybody wants expedition.
Yes.
Now, suppose, my lord, after 3 weeks or 4 weeks, the settlement fails, then, my lord, this appeal has to be revived again.
Yes.
So in the meantime, if your lordships could consider this and perhaps clear one part of the arguments, which will ultimately have to be made if the settlement
We have
fails.
no problem. Let us do it. Huh?
I don't, subject to what falls.
Let us. We don't want to rise now immediately.
Right. Particularly because the matches have been released. I was told about an anecdote, or not an anecdote, but what happened in court regarding release of a matter. But I can narrate that only, I think, outside court. Some senior counsel was asked by a very.
এক সেকেন্ড লাইভ স্ট্রিমিংটাকে বন্ধ করো।
Year 2000, this suit was filed. The plaintiff, respondent number 1 to filed a suit being such and such in this honorable court, praying inter alia for a declaration that the respondent number 1 is entitled exclusively to use the marks Tractel and Terfor as the owners of the aforesaid two trademarks registered in its favor, and also the device of a man pulling a rope, and the defendants, their servants and agents, had no right to use either of the said trademarks or the names in respect of its products, or as part of their corporate name, or use the said device or make any representation that they were associated with these marks, or that the respondent number 1 as its owner in any manner whatsoever. Now, Millard, thereafter, the respondent number 1, that is, Millard, my client now, the appellant, respondent number 1 is the respondent. Yes, the plaintiff also filed an application in connection with the present suit being such and such, and various orders were passed. The appellant had all along been represented through its advocate, Mr. Das, to whom all necessary documents were handed over to conduct the case on behalf of the appellant. Now, February 14, 2012, the appellant was constrained to appoint another advocate in record because the previous learned advocate, who was all along representing the appellant, was not keeping well and or was also not in a position to represent the appellant in the present suit. However, the appellant was not able to retrieve all the records of the case from its first advocate in record. The changed advocate in record of the appellant entered appearance on or about February 14, 2012. The appellant was constrained to trace out the case records from its office records, although due to passage of time, it became very difficult for the appellant to trace out such old records. 23rd July 2018, the application filed by the respondent number 1, that is the plaintiff, being GA number such and such, was dismissed for default. Then, after passage of a long time, the respondent number 1 filed an application for restoration of the said application. The appellant had duly opposed the said application. Then, 16th of December 2020, this honorable court was pleased to allow the application filed by the plaintiff, being GA number 2953 of 2019, and restored the application, being GA number 3480 of 2000. It was inadvertently submitted on behalf of the appellant by the learned advocate then appearing for the appellant that the written statement on behalf of the appellant was already filed, because the learned advocate then appearing on behalf of the appellant was under the mistaken belief at that point of time that the written statement had been filed in the present suit. Thereafter, it transpired that the written statement on behalf of the appellant had not been filed in the suit. Then, after 16th of December, after the order was passed and the case file was traced out from records of the appellant, it transpired that the written statement had not been filed. Now, thereafter, the appellant duly provided the necessary instructions and the documents afresh to its then newly engaged learned advocate on record for preparing the written statement. The then learned advocate on record duly engaged a junior counsel to draft the written statement. The learned junior advocate duly drafted. The draft written statement was duly forwarded to the appellant for its comments and approval. Several conferences were required to be held between the concerned officials of the appellant and its learned advocates. Also, due to the vintage of the suit and or its records in the absence and or non-availability of the concerned officials of the appellant who were dealing with the present suit in or around the year 2000 when the present suit was instituted, to provide instructions, the appellant and or its learned advocates faced extreme difficulty in finalizing the said written statement. The appellant provided its comments on the said draft written statement. Finally, the written statement was finalized by the learned junior advocate for the appellant. Due to the raging pandemic situation prevailing in the country, it became difficult to take appropriate steps in a timely manner. Then Millard, the then learned advocate of the appellant, duly sent the settled written statement to the concerned officials of the appellant at Haryana, because Millard, my operations, although the registered office is here, the operations are in Haryana. The concerned official of the appellant, after receipt of the said written statement, duly affirmed, verified the same at Faridabad, Haryana on 4th April 2022. The affirmed and verified written statement was thereafter sent back to the learned advocate of the appellant at Kolkata. A copy of the said written statement was also duly sent to the learned advocates of the respondent number 1. Of course, then Mrs. Khaitan and company was there, by post by the appellant under cover of a forwarding letter dated 4th April 2022. Then 20th September 2022, the suit had appeared in the list of this honorable court. However, the then learned advocate of the appellant had missed the list and hence could not appear before this honorable court when the matter was taken up for consideration. By an order dated 20th September, this honorable court was pleased to fix the matter on 18th November 2022 for hearing ex parte against the defendant number 1. That is, Millard, my client, the appellant. It, however, appears that the respondent number 1 had not brought to the notice of this honorable court that the appellant had duly served a copy of its written statement upon the learned advocates of the said respondent plaintiff. Then 17th of January 2023, the appellant filed an application being such and such for recalling the order dated 20th September, that is, Millard, fixing the suit for ex parte hearing, and for extension of time to file written statement. Now, 28th of March 2023, the said application appeared in the daily peremptory cause list of such the learned judge in the ordinary original civil jurisdiction. By an order of the same date, the said application filed by the appellant was dismissed. Then April 2023, after this order was passed, the appellant engaged Mr. Amit Kumar Shaha, my learned friend who is now appearing, learned advocate, as its new advocate on record in the suit, and all other connected proceedings in place instead of its earlier advocate on record, after the appellant obtained a no objection from the previous advocate on record. Then, Millard, in April 2023, the appellant, through its new advocate on record, preferred an appeal being APO number such and such before a division bench of this honorable court against the said order dated such and such, passed by the learned single judge in the suit which was originally marked as such and such. Then Millard, this is interesting because this explains why it was not brought to the notice of the learned single judge that the matter stood transferred to the commercial division. Although by operation of law, in any event it did. May 2023, one Madhusri Chakraborty, director of the appellant, filed an application in the suit, that is CS number 340, which is originally numbered as GA number 6, praying for being added as a party defendant in the said suit, being CS number 340 of 2000. 19th of June 2023, the said application was listed before the Honorable Justice such and such, learned judge, as a new application in the cause list of the learned judge in the ordinary original civil jurisdiction. When the matter was taken up for hearing, the learned counsel appearing for the respondent number 1, that is, Millard, the plaintiff, relied on an order dated 24th of January 2023, to which I'll draw your lordship's attention, passed by the Honorable Justice Sugata Majumdar, directing that the suit be placed before the appropriate determination, the suit being related to intellectual property rights. It was contended by the respondent number 1 on the basis of the said order that the said application ought to be listed before the commercial division and not in the ordinary original civil jurisdiction, and that this honorable court has no jurisdiction to take up the said application, that is, Millard, for addition of party, as an ordinary civil matter. As stated above, the present advocate on record, Ms. Sri Amit Kumar Shah, was entrusted with the matter in April 2023, after the appellant obtained a no objection from the previous advocate on record and engaged Mr. Shah as its advocate on record in the suit and all other connected proceedings in place instead of its earlier advocate on record. The appellant was unaware of the order dated 24th January 2023, which we have said on affidavit mail. No copy whereof was supplied by the previous advocate on record to the defendant number 1. The appellant was in fact not intimated or made aware of any order dated 24th of January 2023. The said order dated 24th January 2023 was also not a part of the records which were handed over by the appellant's previous advocate on record to the present advocate on record. Upon the said submission being made on behalf of the respondent number 1, the learned judge directed the matter to be listed on 26th of June 2023.
Mr. Chatterjee.
Yes.
Likho. Mr. Obijit Chatterjee, learned senior counsel, representing the appellant, begins his submission but does not conclude. Stop. এটা কত নম্বর গো?
This is 24.
24. Paragraph. It'll remain in the list tomorrow?
Yes.
Kalke, let this matter be listed again. Kalke date dita for further hearing, comma. As এটা তো উপরের দিকে তুলে দাও, যেগুলো হিয়ারিং হয়েছে উপরের দিকে তুলে, হ্যাঁ উপরে তুলে দাও। 1 2 করা আছে, তাহলে এটা 3 হবে। হ্যাঁ, as তাহলে আইটেম নাম্বার বলে দাও কত, under the heading appeal from orders. Thank you.
No.